What is this? There's like in the green item number 14. Just a minute. There's not yet. क्या चीज़ है? क्या चीज़ है ये?
एग्जीक्यूटिव का ऑर्डर है लास्ट में क्या ना
इसमें हम फॉर द रेस्पोंडेंट चलो नेक्स्ट वीक के में हमको कोई ये नहीं अभी
Serial number 14.
14
No option but to stay. ये तो करना ही होगा ना
हाँ हाँ अरे उसके लिए नहीं हम I'll never object that your lordship may not take it. I say that only for today because your lordship may kindly fix it on Monday or on 19-20.
Then the stay has to be granted.
हाँ ठीक है that I cannot I must not object because I've been seeing that the trial court despite the hearing they are but the only thing that it may be up to a particular date and
Yes, yes.
the matter may
Only
be
till the next week.
fixed at the top of the
They will not be able to get away with stay order and keep the money. वैसा या नहीं?
I'll not object to any stay being granted by
You have appeared. All the parties have appeared.
only two for one
SC number 102 of 2025 with IA number 9345 of 2020. The case has been mentioned for being taken up today. Considering that a number of cases have been fixed, the court is not likely to reach the matter. Also, for the applicant has produced a copy of order dated 9/1/2026, wherein the learned executive court has observed that since no order has been received from the High Court, the court has to proceed. The learned counsel for the appellant submits that the second appeal has been admitted by framing substantial question of law by order dated 12/8/2025. Counsel for the respondent has submitted that he is otherwise ready to do the case. A date may be fixed for next week. Considering the submissions, let this matter be listed on. क्या matter? क्या substantial question of law?
NC I'm not
Yes.
JBC
JBC.
BBC
On 19th of January 2026 to be taken up as first case at 10:30. After synopsis the manager, दोनों जने. Counsel to furnish short synopsis of their argument in the light of the substantial question of law already framed. Till 19th of January 2026, the further proceedings in execution case number 68 of 2024 pending before the court of Civil Judicial Division at Ranchi shall be instituted.
very much
इसको
obvious
लगाना है. अने आइए डिस्पोजल नहीं आइए को डिस्पोजल मत करिए इस टाइम ये डिस्पोजल कर देते हैं आइए इस डिस्पोजल
From the supplementary list under heading for orders, fixed days
Madam,
and
your case will be
30.
taken up in the second half. We have order 41 rule 11 matters are taken up in this.
Item 2, second appeal 40 of 2005.
Second half. Okay. SA 40 of 2009. By order dated 18 November 2025. The learned registrar general of this court was directed to take up the matter with the judgeship of Sahibganj and Dilka, so that the records of titleship number 2 of 1969 is traced out. A communication has been received from the judgeship of Dulka that the case records are not available, are not traceable at Dulka. However, no report has been received from Sahibganj. Pursuant to order dated 18th of November 2025.
The letter that came from the principal investigator, they sent the report to the while the title appeal was going on. So they sent the title suit report to Sahibganj, and when the title appeal was disposed, it was supposed to return back to the title to the.
They will find it out and they will give a fresh report.
This is what they have said in the letter.
Which letter? Have we received any letter from Sahibganj?
No, from the principal.
Sahibganj will not say anything. They will also say something. And we do not know where it is. The learned registrar general is directed to immediately take up the matter with the judgeship of Sahibganj. Who is to inform this court about the availability of record. Post on Monday. इसको ऑर्डर साइन करा के कम्युनिकेट करना.
On that we must have discussed with the judge. He pointed out that there were two appellants, both of whom had died during the pendency of the first appeal before the appellate. And we were the original respondent there. So we could not have made any substitution. When the appeal was filed by us, then notices were issued and then it was reported that they are dead. Then upon inquiry it came to our notice that they had already died. They were in 1985 and that means during the pendency of the first appeal. First appeal was pending from 1976.
So that order is a nullity. Who are you? Or legal years of the original appellants?
Yes.
He appears for the legal years.
Yes. Here, after getting that knowledge, we filed an application under Order 110 that was allowed by the Honorable Court, and based thereon, they have been. So, because there were
So the appellate judgment is a nullity.
there are two aspects to the claim. One, that because there were only two appellants, so the entire appeal itself had happened. It is apart from the fact that it was a nullity also. Even if one of the appellants would have died, then here both the appellants had died.
So the appeal itself had abated.
Yes, entire appeal had died.
So what is the
So
consequence?
one fact also we must disclose that we have mentioned in our petition that upon inquiry about one we came to know that she had died in 1985, but about the other appellant no date of death by us. But we have mentioned a very clear statement that they both had died during the.
No, I get it. I get it that order has been passed in favor of a person who had already expired,
Yes, yes.
right? So according to you, order is a nullity, the appeal had
Nullity also and appeal
Abated
had,
also.
entire appeal had abated because both the appellants had died. It is not a case that
That's
only
right.
one of them.
So what is the consequence?
Consequence would be that at least the impugned order would not
That side it will
cannot
not
be
sustain,
sustained.
but still do the respondent will get any opportunity? No. Why will they get any opportunity? Will they get any opportunity? Are they entitled to any opportunity under law?
Yes, yes.
Can a litigant not
I do
take steps
understand
for
that,
substitution and then at the appellate stage they say no, my predecessor had expired, or you can say in this manner because
because one stand would be there. Because both the appellants had died, then they can say that they were not aware about the appeal itself.
but that is not their case.
No,
They have not
their
said
case,
anything.
but I am just barely disclosing what can be there because I don't want to get a shortcut order and but this is a situation which would be there. That the appeal at least abates until and unless the appellate court passes an order setting aside the abatement and also condoning the delay amount, which is
So we can
absolutely
can we leave it open for the respondent to take appropriate steps?
yes.
Whatever be the steps as per law, we do not know what steps they will take and what steps they will
Yes,
not
yes,
take.
yes, yes.
And even the abatement is to be set aside or it is not to be set aside, it is for the discretion of the court.
Yes, absolutely.
The
It
court,
would be for
everything has to be taken care of, the
Yes.
limitation, everything has to be taken care of by the court.
There may be a situation why I am not pressing that another point because there may be a situation where in a case where immediately the appellant has died, the appellate court has passed an order and we have filed an appeal. So there may not be much delay between the date of death and disposal of the appeal itself. Then to hold it here in second appeal that the entire first appeal had abated, that would be a very harsh. But here in this case, absolutely, the death had occurred in 1985. The appeal was of the year 1976. It was disposed of in 2004. After 20 years, it was disposed of. So here in this case, at least
If we simply observe that the appeal has abated and the judgment is a nullity, that should suffice. If they want to do anything, they do.
yes, and they have not been able to controvert that the date that they have not died during the pendency of the first. If they are not able to controvert this fact, then this appeal is of the year, the second appeal of the year 2005, and this substitute order 1 to 10 was allowed in 2015. So if they are able to show that my statement that they have died in the first appellate stage itself, if they say that my statement is false and they are able to prove, then the matter would be different. Here they are not able to controvert that they had already died during the pendency of the first appeal.
तो फिर हम लोग रिकॉर्ड किस लिए खोज रहे हैं?
नहीं, लेकिन this otherwise is a serious matter where the executive side of the state absolutely no record keeping is there. So at least in civil court, the records must be properly maintained. This is only on the other administrative side of the high court. Otherwise,
The suit was what was the suit for?
It was the suit for declaration of right and recovery of position in
Recovery also.
recovery of position also.
You are the
I am the original plaintiff.
you won in the trial court or you lost in the court?
The suit was declared. It was a judgment of recovery because the title.
इसको फ्राइडे को रखिए 10:30 और इस ऑर्डर को तुरंत कम्युनिकेट थ्रू फैक्स, राइट? At this stage, the learned counsel for the appellant has submitted that both the appellants before the learned first appellate court had expired during the pendency of appeal, and by filing this appeal, the petition under Order 1 Rule 10 of CPC was filed, impeding the legal years of the deceased appellants of the first appellate court, and they have already appeared. The learned counsel submits that since there were only two appellants and both had expired during the pendency of the first appeal, the judgment itself is a nullity, and the entire appeal has abated. However, this aspect of the matter will be considered on Friday, on the next date. ठीक है? आप सोच के आएंगे क्या बोलना है, इसीलिए लिखा है Friday 16, इसको कम्युनिकेट करिए आज, ऑर्डर लेके आइए और कम्युनिकेट करिए.
For finance to item 1, second appeal 63 out of 2012.
This appeal has been filed against the judgment and decree dated 10/5/2012, passed by the District Judge Chatra, whereby title appeal number 28 of 2009 has been dismissed, and the judgment and decree dated 28/4/2009, passed by the subject matter Chatra in title suit number 23 of 2003 has been affirmed. The learned trial court had decreed the suit, and the learned first appellate court has affirmed the judgment. Consequently, the defendants are the appellants before this court. This appeal was admitted. The suit was filed.
For declaration with right title, interest and possession over the suit property, and possession and possession in the alternative for the appeal.
The suit was filed for declaration of right title and interest with respect to the suit property, along with house standing thereon. And a further prayer was also made seeking confirmation of possession over the suit property.
Or in the alternative for recovery.
And in the alternative, if the plaintiff is found dispossessed from the suit property, there was a prayer made for recovery of possession also. This appeal was admitted for final hearing by the order dated 23/7/2015 on the following substantial question. The learned counsel for the respondent at the outset has submitted that the question of law as framed by this court is not a substantial question of law, inasmuch as there is no scope for reappreciation of evidences placed on record at the second appellate stage in absence of any perversity in the matter of appreciation of evidence. The learned counsel has submitted that the substantial question of law does not refer to any perversity in the matter of appreciation of evidence. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but the judgments are perverse, and the document and the materials on record have not been properly appreciated, and therefore the substantial question of law has been likely treated. By advancing the arguments on merit, the learned counsel for the appellant has submitted that the property involved in this case was purchased from the joint family fund, in as much as the consideration money was paid by the personal earning and stridhan of the mother of both the parties. The learned counsel submits that this aspect of the matter, having not been considered, the substantial question of law framed by this court be answered in favor of the appellant. He has submitted that. That should be sufficient. The learned counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that the plaintiff has failed to, the defendant has failed to prove that the property was purchased from the personal earning of the mother slash stridhan, and the property was standing in the name of the plaintiff. He claimed that the property was purchased from his own income. The learned counsel has also submitted that there is no nucleus in the family to purchase the property. She has also submitted that the mother was also examined as a witness before the court, but it has been recorded by the learned court that she did not depose that the property was purchased, that she had, that the property was purchased from her stridhan or from her income. And this aspect of the matter has also been considered by the learned court to come to a finding that the property was not the joint family property and was the self-owned property of the plaintiff. She has also submitted that every aspect of the matter and all the materials on record have been taken into consideration. The learned counsel has also submitted that the defendant had relied upon Exhibit A, which is the deed of partition, on 22/10/2002. She submits that the signature, the alleged signature of the plaintiff on the deed of partition was to be examined through handwriting expert, and for that purpose the petition was also allowed. At the instance of the defendants, but the defendants failed to comply with the direction of the court and did not deposit the cost of the expert, and the alleged signature of the plaintiff in the partition deed, Exhibit A, could not be examined by expert. The learned counsel submits that the conduct of the defendant has also been taken into consideration while deciding the case. That's all. यही है तो चीज बोलना. After hearing the learned counsel for the parties,
Appellate court.
sorry,
Appellate court का judgment नहीं है.
the learned counsel has also relied upon the judgment passed by the learned first appellate court, paragraph 19. To submit that, the learned First Appellate Court has come to concurrent findings that the property was not the joint family property. After hearing the learned counsel for the parties, this court finds that the suit was filed by the plaintiff claiming that he was the absolute owner of the suit property and the building standing thereon. And it was acquired by his personal and exclusive fund through registered sale dated 3/1/1979. And the plaintiff had been in exclusive possession of the suit property and got his name mutated. And Jamabandi was also opened in the name of the plaintiff. He had constructed a house on the property and municipal taxes were also being paid by the plaintiff alone. It was the case of the plaintiff that the plaintiff belongs to a very poor family having limited source of income, and therefore he left his native village in the year 1963 and began to reside at Chakra by doing barber's job. The plaintiff earned enough through the profession. It was stated that the father of the parties died in the year 1994 in native village and the mother was still alive. It was a case, the defendant number 1 is the brother of the plaintiff who also decided to earn a livelihood at Chakra and sought for plaintiff's permission to reside temporarily in the plaintiff's house at Chakra, which the plaintiff permitted and allowed him to stay in one room with a clear understanding that as soon as the defendant would get alternative residential accommodation, he shall vacate the plaintiff's house. And the defendant established his own haircutting salon. The defendant did not vacate the portion of the premises and finally refused to vacate on 25/11/2002. A proceeding under section 144 of CRPC was also initiated between the parties, and the rule was made absolute against the defendants. And ultimately it was also stated in the plaint itself that no panchayati was convened and the paper of panchayati was forged and fabricated, and it was denied by the plaintiff that the plaintiff ever made any signature on the same. It was contended by the plaintiff that the defendant was a mere on permissive possession in the front of the house as a licensee, and he was liable to be vacated. The defendants jointly contested the suit by filing written statement, asserting that the suit itself was not maintainable, and they also asserted that amicable final partition took place between the parties in the year 1992, and a period of 12 years had already expired, so the suit itself was barred by limitation. It was contended that the defendant owned and possessed 40% of the suit land and the plaintiffs owned and possessed 60% of the same. And the defendant number 1 was allotted front portion of the land adjoining to the Pakka road. It was a case of the defendants that the father of the plaintiff and the defendant number 1 had originally settled in Basaria, where he acquired some land. And since there was no facility of education, so the parents of the plaintiff and the defendant number 1 decided to purchase some land at Chatra and to construct a house to get their children admitted in school. And accordingly, 4 discipline of land was purchased in the name of the plaintiff, and a small Kacha house was constructed. It was contended that the major portion of the consideration money with respect to the suit property and the cost of construction was paid by the mother of the plaintiff and the defendant number 1 out of her Stridhan property. It was also contended that the defendant number 1 had also contributed considerable amount in the construction of the house, and it was asserted that the land belongs to the joint family under their father as Karta of the family. And thereafter under the mother. It was asserted by the defendant that on account of differences of panchayati was held in writing and which was reduced into writing, and both the brothers had accepted the same and signed the award of the punches. The defendants denied the assertions of the plaintiff in the plaint. Altogether, 8 issues were framed by the learned court, which are as follows. Considering the argument advanced on behalf of the appellant, the most important issue is issue number 7. Both the parties, they adduced both the oral and documentary evidence. The issue number 1 and 7 was decided by the learned trial court by paragraph 11. The learned trial court observed that there is no presumption that a family, because it is joint, also possesses joint family property. And a particular member of the joint family may have a separate property. It was also observed by the learned court that in order to render a joint family property, a property to be a joint family property, it must be proved that the family had some property with the income of which the disputed property could have been acquired. And meaning thereby, the nucleus to procure the property is required to be proved. A person who asserts that the property is a joint family property, he has to prove the nucleus from which such property could be acquired. And only then such property can be presumed to be a joint family property. Applying the state principle, the learned Trial court considered the materials and observed that no nucleus of joint family fund has been shown by the defendant, and the defendant also failed to prove that the property was purchased from the personal earning of the mother or her Sridhan. The court also observed that DW4 was the mother of the plaintiff and the defendant number 1, who had stated in her examination in chief that the land was purchased by her husband on behalf of joint family fund. But she has not stated that she made any contribution to her earning or through her Sridhan for making payment of the consideration amount of the disputed land, or in the construction of the house constructed over the disputed land. The learned court further considered all the oral and documentary evidences on record and ultimately held, and also the Exhibit A, the LS deed of partition, with respect to which the learned court also observed that the plaintiff had disputed his signature on the LS deed of partition, and a petition was filed by the defendants to get the handwriting and the fingerprint examined through expert, which was allowed on 26/8/2008, but the defendants failed to comply with the direction of the court and did not deposit the cost of the expert. And as such, the signature of the LS signature of the plaintiff available in the partition deed with the bracket Exhibit A could not be examined by the expert. The court observed that there is laches on the part of the defendant, and therefore adverse and inference is required to be drawn against the defendant. The court ultimately recorded that from careful scrutiny and minute observation of the oral and documentary evidence, came to the conclusion that the property was the exclusive and self-acquired property of the plaintiff, and the defendants had not succeeded to prove that the same has been acquired through joint family fund, and ultimately held that the plaintiff had valid right title, interest and possession over the suit property. The suit was decreed, and the defendants were directed to vacate the portion of the suit premises which was under their occupation within 3 months from the date of the judgment. The learned First Appellate Court also considered the materials on record by framing the moot question involved in the case in paragraph 11 of the judgment as to whether the suit property is self-acquired property of the plaintiff or it is a joint family property, and whether the consideration money was paid by a joint family fund or it was paid exclusively by the plaintiff from his personal and independent income. The learned First Appellate Court has also considered all the materials on record and considered the principles of law governing the case in paragraph 16. As follows. The learned court ultimately applied the principles of law and recorded finding in paragraph 17 as follows. The exhibit A, which was relied upon by the defendant, was also rejected by citing reasons in paragraph 18 of the judgment. The court further also recorded that the exhibit A was an unregistered document and a partition deed under law is required to be registered, and observe that unregistered partition deed is inadmissible under law. The learned court, by ultimately upholding the judgment in paragraph 19, has observed that the learned trial court has scrutinized the oral and documentary evidences by recording that the property was the same required property of the plaintiff and was not a joint family property. And the learned court had rightly held so. This court finds that all the materials on record have been duly considered by both the courts, and the plaintiff, by applying the correct principles of law, the plaintiff has miserably failed to prove that the defendant had miserably failed to prove their stand in the written statement that the property was purchased from the joint family fund or from the Sridhan of the mother of the plaintiff and the defendant number one. The law is well settled that merely because there is a joint family, all the properties do not automatically become joint family property unless the nucleus is proved. Admittedly, the scrutiny of the judgment reveals that the defendant had failed to prove the nucleus for the purchase of the property, which was purchased exclusively in the name of the plaintiff.
No direct judgment. 2003 10 SSC page 310 paragraph 18.
2000
इनके तरफ से
ठीक है, उनकी तरफ से the learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in 2003
10 SSC
10 SCC
page 310
310 para
18.
18, ठीक है, इनकी तरफ से डाल देंगे 2003 volume 10 SCC 310 ये देखिए. Accordingly, this court is of the considered view that the findings of the learned court are not vitiated in any manner, and the learned courts have properly considered the oral and documentary evidences adduced on behalf of the parties in the correct perspective and have also applied the right principles of law while deciding the case. The substantial question of law is answered against the appellant and in favor of the respondents, and consequence of this appeal is dismissed.
from day list for final list of item 1, second appeal 131 of 1998.
Third candidate, I will look to order number 79, dated 10/12/2020.
This,
Third candidate, I will look to para 13 of the same order. Letter counsel for the respondent has submitted that exhibit 1 to exhibit 10 are linking evidence to show that Vidya Jainuddin was son of Bibi Firoza Khanum and not Bibi Jamunati Khanum. However, they submit that they shall place the exhibits on the next day and he has to go through it. Post this matter. Now that my friend has already proceeded with the argument,
yes.
Mr. Gupta. He will
No,
proceed.
but now the respondent has to act. Let them act. आप इस
हमें रिस्पोंडेंट है मोहम्मद मुस्तफा मेरा नाम है। हम वकालत का ले लिए अपने वकील से तो समय चाहिए
क्या चीज़ भी है आपसे मुझे
हमारे इस केस के लिए।
He says that he has taken no objection.
कहाँ है आपका नो ऑब्जेक्शन? आप फाइल क्यों नहीं किए? तो पार्टनर
आज
मैटर
लेके आज हम आजे हुआ है आजे लिए इसलिए
आपने
हमको
अपना वकील तय कर लिया है।
न किए हैं इसलिए हमको समय चाहिए।
पार्टनर मैटर में इस तरह से टाइम नहीं होता है।
न ठीक है हजूर एक मत आपसे प्रार्थना करते हैं कि
प्रार्थना तो ठीक है, लेकिन आप वकील भी तो तय करेंगे ना।
तय कर लेंगे हमको कुछ समय चाहिए। हमको आप समय दे दिए हम कुछ तय कर लेंगे।
कब रखें? कल रखें?
न कल तो नहीं हो सकेगा कम से कम 6 हफ्ता का टाइम दीजिए। पैसा भी जुगाड़ करना सब कुछ करना है और हम अकेला आदमी है। कम से कम 6 हफ्ता का टाइम दीजिए।
नहीं, पार्टनर केसेस में हम इतना
जी,
लंबा
जी,
टाइम
वो-
नहीं दे सकते।
आपका बहुत बहुत शुक्रिया हम अदा करेंगे। आप हमको कम से कम 6 हफ्ता का टाइम दीजिए। हमको पैसा भी इंतजाम करना वकील भी करना।
वकील तो हम लोग आपको दे देंगे।
वकील का पैसा भी तो है इसलिए हमको 6 हफ्ता
कोई
का
पैसे
कब
का जरूरत नहीं होता है वकील।
होगा।
आप बताइए
कम से कम
आपको
हमको 6 हफ्ता का टाइम दे दीजिए। आपसे प्रार्थना हम कर रहे हैं आप हमको 6 हफ्ता का टाइम दे दीजिए। कम से कम 6 हफ्ता का
ऑब्जेक्ट करेंगे।
कम से
इतना
कम
लंबा
6
टाइम नहीं हो सकता है।
कम से कम
ये
6 हफ्ता का टाइम
6 हफ्ता में तो हम भूल जाएंगे ना। क्या
नहीं
सूरत है?
भूलिएगा। ये केस भूलने का नहीं है नहीं
आप
भूलिए।
भूलिए, आप आपका केस है, आप नहीं भूलिएगा। हम लोग तो रोज ही केस सुनते
नहीं
हैं तो
ठीक है कम से कम एक
नहीं,
मतलब मेहरबानी करिए 6 हफ्ता का दीजिए।
इतना लंबा इस तरह से 6 साल का क्यों नहीं टाइम दे रहे हैं आपको?
ना 6 साल 6 हफ्ता का दीजिए
इतना
ना।
लंबा टाइम नहीं दे सकते।
या नहीं तो फिर अगला केस 9 तारीख को है 9 फरवरी को दोनों को एक साथ रख दीजिए।
कौन दूसरा केस?
Yesterday it was listed.
हाँ दोनों को एक साथ कर दीजिए।
उसमें
No.
भी नो ऑब्जेक्शन ले लिया है।
न उसमें नहीं लिए इसमें लिए हैं
उसमें आप अपीयर हो रहे हैं?
हाँ
उसमें वही अपीयर हो रहे हैं।
उसमें होंगे 9 तारीख को दोनों रख दीजिए। दोनों 9 को कर दिए दोनों हम कर लेते हैं।
अब
No.
उस दिन आपका वकील साहब खड़े होकर बोलेंगे कि हमको तो फाइल देखना है,
नहीं,
हमको
नहीं,
कागज
कुछ नहीं
पलटना है, ये
होगा।
सब कहानी नहीं होगा ना।
कुछ नहीं होगा 9 तारीख को दोनों को रख दीजिए आप। उसको भी 9 इनको भी 9 कर दिया वहाँ भी 9 कर दिया।
मेरा 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 भी
कम से कम एक मरते हमारा
बच्चे में-
समस्या ही करिए। हमको माने सिंगल हम आदमी हैं और बहुत परेशान हैं। हम बहुत परेशान हैं बहुत दिक्कत है हमको। इसलिए आपसे प्रार्थना कर रहे हैं कि आप हमको 9 तारीख का दोनों को एक साथ कर दीजिए। उसके बाद हम आपसे समय नहीं मांगेंगे।
नहीं हम
जी।
दूसरा मेरा
हाँ
सर
एक मिनट सर हमको बोलने दीजिए
अच्छा, ठीक।
सर।
आप तो खुद ही अच्छा वकालत करते हैं। आपसे
नहीं,
बेहतर
सर।
कौन बहस करेगा इसमें?
नहीं सर कम से कम एक बार हमको आप ये कर दीजिए उसके बाद हम आपसे कभी नहीं मांगने आएंगे। 9 तारीख को दोनों रख दीजिए आप। आपका बहुत बड़ा मेहरबानी होगा उधर। इसलिए एक बार हमरा आप प्रार्थना सुन लीजिए एक बार सिर्फ
मेरा छोटा
9 तारीख को दोनों को फिक्स कर
अरे
दिए।
भाई आप इतना बोल रहे हैं, उनको नहीं बोलने दीजिएगा।
अच्छा ठीक
आपने क्या पहले नोटिस दिया था कि आज हम
नहीं।
केस नहीं करेंगे? बताया था कि
ये
केस नहीं
आज
करेंगे।
आज हुआ बात।
आज आज वो है, आज कुछ अचानक हो गया है क्या? आपके सेम केस में तो वही वकील मतलब दूसरा केस में
उसमें दूसरा रहेंगे, उसमें दूसरा रहेंगे,
उसमें दूसरा रहेंगे।
इसमें दूसरा रहेंगे, उसमें वो रहेंगे, इसमें दूसरा रहेंगे।
उस केस में आप उन्हीं वकील को रखे हुए हैं,
उन्हीं रहेंगे,
तो
वही
कोई
रहेंगे।
ग्रीवांस तो आपको लगता नहीं कि वकील साहब से है? काहे के लिए नो ऑब्जेक्शन दे दिए?
ये लिए हम क्या करेंगे, हम बहुत परेशान हैं, क्या करेंगे, मुझे इतना परेशान है कि कहना मुश्किल है। 9 तारीख को कर दीजिए।
ये केस जब 1998 से चल रहा था तब से परेशान नहीं थे? केस हियरिंग शुरू हो गया तो
आप 9
परेशान थे।
तारीख को रख दिए, उसके बाद आप हमको समय नहीं दीजिएगा, एक दिन का नहीं दीजिएगा। 9 तारीख को दोनों केस आप कर दीजिए।
अब हम 2 लाइन बोले,
हाँ।
हम बोल रहे हैं फिर 9 को जो एडवोकेट को इंगेज करेंगे फिर वो बोलेंगे, तो ये इंगेज जो करना है परसों
देखिए, ऐसा
बना
है
दें
कि आप 9 तारीख को तो किसी को एंगेज नहीं करेंगे, ठीक है ना? उसके पहले ही एंगेज
हम
करेंगे।
पहले करेंगे,
तो हम उसके पहले आप जो दिन बोलेंगे हम डेट कर देंगे। उस दिन आपके वकील साहब वकालतनामा फाइल करके अपीयर हो जाएंगे और उनके सामने हम बोल देंगे कि 9 तारीख को हम डेट देंगे। ये तो हो सकता है। और अगर आपको रांची कहाँ का मैटर है
ये गोड्डा का,
गोड्डा का, अगर आपको रांची आने में दिक्कत है तो आप ऑनलाइन भी ज्वाइन कर सकते हैं, कोई दिक्कत नहीं। लेकिन आपके वकील साहब के सामने ये ऑर्डर में लिखाना जरूरी है कि 9 तारीख को हम डेट नहीं लेंगे।
ठीक है, नहीं
ये तो यहाँ पर क्या होता है कि नए वकील आएंगे और नया कहानी शुरू कर देंगे।
नहीं करेंगे हम,
तो आपके वकील साहब आपके कंट्रोल में नहीं रहने वाले हैं।
इस महीना में वकील
हमारे कंट्रोल में आपके वकील साहब रहते ही नहीं है।
इस महीना में हम करेंगे, हम वकील कर लेंगे और 9 तारीख को आपसे डेट नहीं लेंगे।
हम आपका एक डेट कर देते हैं,
9 तारीख रख दीजिए ना।
9 तारीख को नहीं रखेंगे, हम उसके पहले का डेट रखेंगे, जिस दिन हम
महीना का
वकील
लास्ट
साहब को
में
बोलेंगे कि भाई अगला डेट पे आपको करना है तब तो आप करिए, नहीं तो फिर हम आपको टाइम नहीं देंगे।
ठीक है, इस महीना का आखिरी में रख दीजिए, कम से कम हमको 20 दिन का भी समय दीजिए।
हम आपको देंगे समय, लेकिन इस महीना में कोई डेट रखेंगे, आपका वकील साहब अपीयर होंगे,
जी
बोलेंगे कि 9 तारीख को हम बहस करेंगे, हम टाइम नहीं लेंगे।
जी
हम 9 तारीख को केस, दोनों केस एक साथ सुनेंगे, पूरा दिन सुनेंगे, सुबह से लेकर रात तक, जब तक कि डिसाइड नहीं हो जाए।
30 तारीख का
वो
रख
रेडी
दीजिए।
है, अदरवाइज
ठीक है,
दूसरा
30
मैटर रेडी है।
हाँ ठीक, 30 तारीख का रख दीजिए।
इन दी सेकंड वन दे हैव गॉन
30 का रख दीजिए, 9 दिन में
सुप्रीम कोर्ट में गए हैं,
जिसका कल
एसएलपी जो फाइल किए हैं
एसएलपी फाइल का, अच्छा जिसका नंबर
हाँ,
मिला है,
कल नंबर की है।
ये
वो
वाला
केस
तो
एक साथ नहीं सुनवाई हो पाएगा क्योंकि वो
ठीक
तो
है।
एसएलपी में गए हुए हैं। उस ऑर्डर
ठीक
में
है,
आप ही
8
है
में
ना
हो
SLP?
जाएगा, एक दिन आगे पीछे हो जाएगा।
उसी केस में आप ही ना एसएलपी में
जी
गए
हाँ,
हुए हैं।
जी।
तो 9 तारीख को कैसे वो केस डिसाइड हो जाएगा?
वो नहीं होगा तो 8 को रख दीजिएगा, 7 को रख
आप तो
दीजिए।
बहुत सीजन लिटिगेंट हैं।
आप इसको 30 तारीख तक रख दीजिए, कम से कम आप 30 तारीख तक रख दीजिए और 30 को रख दीजिए। उसके बाद हम वकील साहब को बोल देंगे 9 को आपको डेट नहीं लेना।
9 तारीख को तो वो वाला मैटर
ठीक है, वो ये 10 कर दिए, 11 कर दिए, लेकिन 30 तारीख का आप टाइम दिए हम, और उसके बाद जो भी डेट रहेगा हम एक दिन का टाइम नहीं लेंगे। अब 30 का कर दीजिए।
क्या नाम है आपका?
एमडी मोहम्मद मुस्तफा, एमडी मुस्तफा।
आप कौन है इसमें रेस्पोंडेंट नंबर?
कॉर्नर नंबर ये होगा, हम समझे से कर रहा
मोहम्मद मुस्तफा करके तो कोई पार्टी ही नहीं
आपके
है।
पास
अच्छा, मोहम्मद मुस्तफा।
जी,
जिसके बदले सब क्यों
वो साबरा का।
हम सागर
अच्छा, सबरा का।
जी,
आप कौन है सबरा का?
बेटा
Second appeal number 131 of 1991. Mohammed Mustafa, one of the legal heirs of deceased respondent number 1. has appeared in person before this court and he has submitted that he has taken no objection from his counsel. And he prays for some time to engage another counsel. The learned counsel, he also submitted that the matter be posted 29 तारीख को रखें, be posted on 29th of January 2026, and prior to that date, he shall engage another counsel and also brief him. He submits that on the next date, another date be fixed for the purposes of further proceedings, further hearing in this case. ठीक है, उस दिन नहीं करेंगे, अगला डेट ठीक। अगर आपको कोई वकील चाहिए तो कोर्ट से भी हम लोग अमेरिकस अपॉइंट करते हैं, इसीलिए पैसे रुपए के लिए परेशान होने की कोई ठीक। Post on 29th in the supplementary cost list to be taken up at 10. 10:30 बजे आपका पहला केस होगा।
जी सर।
आप चाहें तो ऑनलाइन भी ज्वाइन कर सकते हैं।
जी।
वहाँ जाएंगे आप कौन से डिस्ट्रिक्ट में हैं?
गोड्डा डिस्ट्रिक्ट।
गोड्डा में डिस्ट्रिक्ट लीगल सर्विसेज अथॉरिटी है,
ठीक है।
वो लोग आपको ज्वाइन करा देंगे उसको। ठीक है।
Item 2, second appeal 631 of 2004.
लिटिगेंट्स बहुत एंशियस हो जाते हैं।
हाँ, हम अभी भी ये समझते हैं प्रॉब्लम, लेकिन ठीक है, बस बहुत ज़्यादा स्ट्रेच नहीं
बहुत एंशियस हो जाते हैं, नेचुरल है।
इसी के लिए हम बोलते हैं कि वी आर शील्ड टू द ऑनरेबल कोर्ट। हम लोग जो भी है हम लोग खेलते हैं, फिर हम लोग प्यूरिफाइड वर्जन कभी यहाँ प्लेस करते हैं।
इसीलिए रेलेवेंट इररेलेवेंट
हाँ,
सारे आर्गुमेंट कर लेने का।
हाँ,
कभी-कभी लिटिगेंट को लगता है कि यही सबसे इम्पोर्टेंट पॉइंट है,
सबसे
इट कुड बी इररेलेवेंट,
हाँ,
बट एट टाइम्स
इमोशन ज़्यादा होता है, एक्चुअली इमोशन ज़्यादा होता है देन द बेसिक फैक्ट
एंड यू सी इन क्रिमिनल केस व्हेन अ पर्सन गोज टू जेल, उसका घर परिवार तो फिर भी सस्टेन करता है, लेकिन इन सिविल लिटिगेशन किसी का घर से बेघर होना बहुत सीरियस है। It is it practically uproots the person from the place completely. झारखंड में एक झोपड़ी के लिए भी कोई लड़ रहा है तो बहुत सीरियस लड़ाई है, because he doesn't have an alternative.
और एक चीज है, because इसी के लिए हम बोलते हैं कि many a times people are not able to afford the Supreme Court.
नहीं, आज के दिन में ऐसा नहीं बोल सकते हैं, there is a reason for it. The reason is that legal aid is very low cost.
हाँ, लेकिन
अब लोगों को पता ही नहीं है तो इसका तो कोई कुछ कर नहीं सकता।
लेकिन
legal aid is very low cost and it is नहीं, quality legal aid है, you cannot say quality legal aid नहीं है। Just to share, when I got elevated, I was working as a legal aid counsel in one matter. The litigant came and told me कि आपका एलिवेशन पोस्टपोन नहीं हो सकता है क्या till my case is decided. तो I had to say, I did not know what to say, but it is not that quality legal aid है।
नहीं, लेकिन वो तो out of list of 30, I'm not saying anything about quality, but कुछ लोग pro bono करेंगे, बाकी तो ये रहेगा।
लिस्ट ऑफ 30 मतलब जो आपने लिस्ट की?
हम तो किए हैं और दूसरा केसेस में हम किए हैं,
लेकिन जो कंटेस्टेड केसेस होते हैं और जिसमें एक्चुअल में अभी तो हमने सोचा है कि जो एक लिस्ट है मेरे पास, that is the list of absolutely junior counsels. It is basically some kind of training to them. कि कुछ record मिलेगा, कुछ पढ़ेंगे तो they will next layer of next generation will develop in civil law to some extent. लेकिन अगर हमको एक्चुअल में बहुत ज़्यादा हेल्प की ज़रूरत होगी तो हम उनको थोड़ी अपॉइंट करेंगे, हम आप ही को अपॉइंट करेंगे, चाहे इनको अपॉइंट करेंगे, तो ऐसा थोड़ी है, ऐसा थोड़ी है कि हम किसी को भी अपॉइंट कर देंगे, ऐसा नहीं है, It's not that.
उसके लिए हम लोग कभी मना नहीं करेंगे। एक्चुअल
इनके लिए भी फायदेमंद होगा, सिया लॉ का है।
हाँ?
इनके लिए भी नया लॉ होगा,
ये वाला
सिया लॉ।
शिया लॉ, आई नो शिया लॉ बहुत कम आता है,
बहुत इधर में सिया सेक्टर लोग बहुत कम।
मुस्लिम लॉ के कुछ केसेस डिसाइड किए हैं बट दे आर वेरी वेरी टेक्निकल, और यहाँ बहुत सारे केसेस नहीं भी हुए हैं, बहुत पेंडिंग है मुस्लिम लॉ के केसेस।
सिया लॉ को मैक्सिमम वो उत्तर प्रदेश में, लखनऊ में, इलाहाबाद में।
एक्चुअली अगर हम गलत नहीं तो शायद 1% 1% है टोटल पॉपुलेशन of Shias and 99%.
They convert into Shia person नहीं।
इसके बाकी 99% है जो सुन्नी।
इसका बताइए क्या करना, आप हैं इसमें?
But the parents were not the plaintiff. The suit was agreed. Appeal court has reversed. The point of law, you kindly see, it is 26th of September 2009. Whether the lower court has correctly made the findings of the trial court while
Yes.
there are two suit courts.
Who is the amicus? You are the amicus?
Yes, sir. Item 1 and item 2. There are two.
Okay.
So far as the item 2 you are asking is concerned. With respect to item 2, there is no dispute. So far as the item 1 you are asking is concerned. The case of the plaintiff you are asking that it is in the name of one Vadio Sokia. And the case of the plaintiff is that he was one of the son of one of the common ancestor, that is the Jugal. And he died and he left a widow, and she also died. And when everybody died, the property went to the agents. And I am also one of the agents, and the defendants are also one of them. Our case is that it is a property, it is a joint family property, it is a pastoral property, and everybody has a right, and including myself. So far as the trial court,
So you are seeking partition?
Yes, seeking partition, and I was seeking partition, and I was seeking what partition? Trial court has decreed. Trial court decreed. Appellate court has reversed. The ground for reversal was that the widow of the Vadio Sokia, who was the son of Bikoma, common descending from common ancestor Jugal. His widow, the Mosmat Somri, she has disputed gift deed in the favor of the defendant, two of them. And they have also pleaded that she has disputed some deeds also, in which I was, my father was also one of them. So these are the grounds for reversal. So the learned appellate court, it concluded that it was not a compulsory property, and Vadio Sokia was an outsider, and the property which was recorded in the name of Vadio Sokaria is not subject, cannot be a subject matter of auction. And what if the parties are in
The widow was wife of Bodio.
yes, widow was Osman Somri.
Bodio was the recorded.
Vadio is the recorded tenant, so with respect to the item number 1.
What about item number 2?
So far as the item number 2, Bernard, there is no dispute. But Bernard, the London Appellate Court has also reversed that also on the ground that the evidence on record suggests that they already punished.
So you have no grievance so far as item number 2 is concerned.
So far as the item number 2 your lawsuit is concerned, we had claimed in both the cases. One third, but so far as the one third is concerned, there is no dispute with it.
With respect to item number 2, you say that it was already partitioned.
No, we say that it is.
So you have grievance with item number 2 also?
Yes. The whole judgment and degree has been reversed. Well, let us show the first one, the backward.
Yes. Why the respondent is not appearing?
Respondent was appearing.
Respondent was appearing and you were appointed as amicus, right?
On one date they were not present.
One date only they were perhaps not. Thereafter, God has appointed him. I remember.
Oh, Baleshwar Yadav. Baleshwar Yadav.
Yes, sir.
You can now flash. Yes, let us see the judgment.
Yes.
Please place the judgment because the nature of substantial question of law, we have to see the entire judgment.
Yes.
Because we have to find out whether reasons by reversing the judgment, the reasons have been signed out. Okay. Reason, पढ़िए.
Yes.
तेजी से पढ़ सकते हैं.
Issues.
नहीं आप तेजी से पढ़ सकते हैं. I have to know the case of the respective parties
Yes.
and then I will come to the issues.
Yes. But may kindly see the trial for this.
Yes.
Suit has been filed by 14 plaintiffs who are namely Badu Mahto, Rukni Devi, Sudama Devi, Kedar Mahto, Munshi Mahto, Parmeshwar Mahto, Kamsar Mahto, Devanti Kumari, Nitya Devi, Arwa Devi, Baleshwar Mahto, Gita Devi, Vishnu Mahto.
Names may not be relevant. You may proceed. Seeking partition, item number 1 and item number 2.
Against 14 plaintiffs and 14 defendants for seeking partition of property, item number 1 and item number 2 of Schedule A, which is the part of the claim to the extent of 1/3 share in their claim. During the course of trial, one defendant, 14, Dina Mahto died and he has been substituted for his legal head by graduated professor Arlan Jindri Kausalya sentence. After the suit has been filed, the notices to the defendants were issued and the defendants were paid to 13 represented by one set of lawyer and 3 to 6 are contesting defendants by the another set of lawyer. Might representative statement secretary. The suit proceeded as party which is evident from the order sheet. Case of the plaintiff, particularly, the case of the plaintiff in brief according to their joint claim is that plaintiffs and defendants are proportionally number of proportionally Hindu and divided joint family and are descendants of one common ancestor Jehalman, who died before the last federal survey, leaving behind his sons Bhikari Mahto, Vilas Mahto, Nanu. Besides a grandson, Bundiya Sokaria, of his breed is his son, Hiko Sokaria, in the state of Jharkhand. The case is further made out that the Jehal Mahto common ancestor causes of certain lands in village Bandarvela and documented separately and respectively in Khata number 33 comprising of 38 blocks total 6.50 acre and Khata number 22 measuring area plot number 131 having an area of 10.38 acres. In support of same schedule rate has been amended with the plan. It is further made out that Khata number 23 of Bandarvela are recorded in the name of grandson Bulia Sukulia, who was the grandson of Vihat Mato and the common ancestor of the plaintiffs and defendants both. In the ancestral survey in Vaidi Khata, in joint name of Vikhari Mato, Ulas Mato and Nanu Mato, the sons of the Jahan. It is further stated in the claim that the Bulia Sukulia recorded tenant of Khata number 33 of village Bandarvela was the proportionary state of jointness with his uncles and cousins, and Vikhari Mato, Ulas Mato, and Nanu Mato and their sons died in the year 1935, leaving behind his wife Mohmad Sundri and a daughter Hamni, who unfortunately died after the marriage, predeceasing her mother Sundri, and Sundri also died sometimes in the year 1954 without any marriage. This means it is a case of the plaintiff that after the demise of Bulia Sukulia and his wife Sundri, the Vikhari Mato, Ulas Mato and Nanu Mato were the next pregnant and they came in the joint possession of the land of Khata number 33 of Bandarvela, recorded in the name of Bulia Sukulia, who was their own nephew and by inheritance and succession under the land property of Khata number 33 of village Bandarvela involved upon this. It is the further case of the plaintiff that they are in the line of the descendancy of Vikhari and who had 1/3 share in the whole property in item number 1 and 2 of the schedule A. It is further case of the plaintiff that there was neither any partition given effect nor the recorded tenant, either by means of norm or even otherwise, but the recorded tenants were in separate position of some of the plots of Khata number 22 according to their suitability and convenience, which were recorded in their separate Patiwari, but the major portion of land of Khata number 22 were recorded in Mark. It is by passage of time that the parties of the suit increased in feeling inconvenience, not only in conservation but also otherwise, and demanded partition of the land of item number 1 and 2 of schedule A, and the defendant generally agreed and assured, but later on resigned and refused to request partition of the land. And also necessity of filing the suit in favor of the cause of action arose on 5/9/97, which the defendant lastly refused to go for partition of the land. The suit valued as 85 for the purpose of the court. But since the present suit is being one of the simple partitions, which we have been
संजय कुमार पांडे को आर्गुमेंट करना था मेरे, सिर्फ एक दिन के लिए तबीयत उनका खराब है कल।
आप लोग तो आए भी नहीं, आपको बुलाए हैं तब आप आए, तो एडजर्नमेंट नोटिस भी नहीं की।
हम तुरंत आ रहे थे, हमारे दौड़े आ रहे थे,
दौड़े आ रहे थे, आधा घंटा से हम सुन रहे हैं इसको। एडवोकेट ऑन रिकॉर्ड कहाँ है?
एडवोकेट ऑन रिकॉर्ड है मेरे 16 नंबर में, मेरे तो ऑनलाइन है वो।
आप तो कई डेट से नहीं आ
रहे।
कल क्या कल के लिए रखें? कितना डेट से नहीं आ रहे? बीमार चल रहे हैं क्या 6 महीना से? Yes? For so many dates your counsel is not appearing before this court. We have to appoint an amicus. Sorry what? You don't value the court's time. There is no adjournment request. Why should I adjourn it at your instance? You have not given any adjournment slip.
मैडम काउंसिल का बीपी और कोलेस्ट्रॉल दोनों बढ़ा है मैडम, इलाज जो इनको आर्ग्यू करना है, इलाज भी चल रहा है मैडम, बोलेंगे तो हम मेडिकल का पेपर भी दिखा रहे हैं
वो हम नहीं
सिर्फ
जानते।
कल पे रख दीजिए मैडम कल
कब तक ठीक हो जाएंगे?
मैडम दवा ले रहे हैं नॉर्मल हो रहा है मैडम कल कर लेंगे मैडम सिर्फ कल पे रख दीजिए इसलिए कल के लिए आगे बोल रहे हैं मैडम और कुछ बोलिए हम खुद ही गए थे उनके साथ दिखा रहे हैं
ठीक है, कल आपके आर्गुमेंट के लिए रखेंगे, आप इनका आर्गुमेंट सुनिए। कहाँ है आपके एडवोकेट ऑन रिकॉर्ड?
चेम्बर में है मैडम
हाँ तो आर्गुमेंट तो सुनेंगे ना, आपकी लाइन का टाइम लगेगा, आपके आर्गुमेंट के लिए कर रहे हैं। ठीक है, बुलाइए उनको। Yes, please.
Critics have played on the following beliefs.
That we have seen. These are the evidences placed on record by the plaintiff.
In order to prove these case, plaintiffs have.
That's right, we have seen this. Now, out of the defendants who appeared and filed a written statement, para number 7.
Out of the defendants who appeared and filed their respective written statements, who are Gender Master, Atul Master, and contesting defendants, and they have filed their joint written. The defendant 10 to 13 have filed their respective written statement. Contesting defendant in the written statement in para 5 totally denied the land of Jharkhand by 33 of village Sundargarh. This is item number 1 of schedule 3, being a joint Hindu family property, and it is never constituted so. Similarly, in the same paragraph, it has been denied by this contesting defendant that the area Superior was in the descendancy of Jharkhand. Which means that he is totally and flatly denied being out of the branch of the Bihar Master as asserted and claimed by the plaintiffs. Very obviously, it is further denied that the current property, landed property of Khata number 23 of the Sundargarh, which stood recorded in the name of Bhuya Superior or even a proportionally property and other denials are also. In order to support the case of the
No, I couldn't get it. Similarly, in the same paragraph, it has been denied by the contesting defendant that Budhiya Supriya was in the descendancy of Jharkhand. He was an outsider.
It's outside.
They claim that he is an outsider.
He is not a family member in the jail.
Okay.
May I read from it?
Yes, in order to support. This is
In
the
order to support the
evidence.
case of denial, the defendants have reduced and examined altogether 10 witnesses.
These are oral and documentary evidences.
Yes.
Then the issues.
In order to support the contention of defendants have also produced certain documents which have been marked as some that evidence receipts. It will be the Mama is tweeted by Musman Sumri, Dukan Masu and others. Exhibit C is cited by Musman Sumri, 4 buildings, 180 meters, who are in native independent. Exhibit C by 1 is cited is tweeted by Musman Sumri in favor of 101. And this exhibit has been marked C by 1.
That's right. You can come to the issues. The issues, issue number 8 is relevant.
Is relevant. Whether the
That is the only relevant issue.
most relevant.
And what other issues are relevant according to you?
7 also is relevant.
Co-parcel 7, 8 and
And 5.
and 5.
These are the issues. It has been dead. And issue number 8 you got.
Yes. You can read it first.
Yes. I would like to just show the finding.
Yes.
Can we see internal page 19?
Yes.
did my lord find on this? Last paragraph I would like to read. On the reasons discussed above, did my lord find? Last. I am of view that the landed property of Khata number 33 was joined and for personal property of the parties and accordingly this issue is decided. Now I would like to place the reasons. This issue is the most important issue out of all, because the termination of Huria Sukaria, the recorded tenant of Khata number 33 and the descendant of Jehal Mato will decide the case of the issue because the plaintiff has claimed themselves to be the descendant of the Jehal Mato. And the fact that the Huria Sukaria being the descendant of Jehal Mato has been denied by the contesting court. It is the specific case of the plaintiff from the plaintiff itself that the Jehal Mato was common ancestor of all the branches, including Huria Sukaria. It is the further case of the plaintiff that Huria Sukaria stayed in a different village, Bandarbela, and during the time of several settlement, his father, Dito Sukaria, who was the son of Jehal Mato, was no more, so the Bandarbela land of Khata number 33 was recorded in the name of the Huria Sukaria. It has been further specifically pleaded in Para 1 of the plan that Jehal Mato was the common ancestor before the last cadastral survey died, leaving behind 3 sons, Ali Mato, Ulas Mato, and Nanu Mato, besides a grandson, Huria Sukaria, whose father was Dito Sukaria, who was the son of the Jehal Mato, and this Dito Sukaria had already died at the time of settlement, and they all lived in the state of jointness in all respect and form a part of the proportionally and divided coming. The contesting defendants number 3 and 6 in their joint written statement is Para 9 have categorically denied this fact of Dito Sukaria, father of Huria Sukaria, and the son of the Jehal Mato. But in the entire written statement, they have not suggested who was the father of the Dito Sukaria. So her denial of contesting defendants on the very important fact, which being the name of the father of the Dito Sukaria, is the best. As much as that the contesting defendants have made active concealment disclosing the name of the father of the Dito Sukaria, where plaintiffs have categorically and very specifically stated and suggested that the Jehal Mato was the father of the Dito Sukaria. The massive denial and active concealment is fatal in the civil proceeding, and being they are taken to be no denial of the fact, and ultimately they are taken as an admission against the party so pleading itself. And I have also noticed that the witnesses who have come forward to support the contention of the defendant, they have also very cleverly made silent and also made denial of knowledge. So when specifically asked by the plaintiff, the counsel as to who was the father of the Dito Mato, though the witnesses are aged about 65 to 75 years of age and of same village of Villa. In this context, first of all, I would like to refer the position of defendant number 3, who has been reduced by the contesting defendant, whose name is Hussaini. He is 75 years of age on the date when they reduced to death. That is 19th of June 2001, belongs to same village, Villa. He is a senior citizen. When a counsel for the plaintiff in cross-examination in Para 5 has specifically asked the name of the father and grandfather of the Dito, he totally denied and stated he does not know the name of the father and the grandfather of the Dito. When I peruse in the evidence in totality, the pattern of his given disposition shows he is well known in the details of the family of Huria Sukaria. But on the important fact of the name of father of Dito Sukaria, he made total silence. Similarly, DW4, who is aged about 62 years, belongs to Bandarbela village, reduced by contesting defendant C to 6 as in Para 8 of his cross-examination that he does not know who was the grandfather-in-law of his son, or grandfather-in-law of his son. Somebody was the wife of Gloria Superior. So again, this witness has shown his ignorance about the name of the important person involved in this case. The counsel for the plaintiff has also drawn my attention toward the important witness DT.13.01.2026, who is the contesting defendant himself. He is stated in para 11 that he was the person who performed the Shraddh ceremony of Sumri, who was the wife of Gloria Superior, and at that time this witness was aged about 15 to 20 years. And as furthermore, in the following paragraphs of his deposition, he has further committed that to meet the expenses of Shraddh ceremony, his father, Rupan Mathur and Deva Mathur, son of Shutar Mathur, had sold out 8 decimals of land of 33, which means that he is referring the land of Somri, which is item number 1 of Schedule 1A. Now the question arises, when he has no right or interest in the land of other number 33, then what prompted or authorized him to make the transaction out of the land? This means that there was a relationship of proportionality between this witness and the recorded deity who was the husband of the most Mahmudi, Gloria Superior. There is a startling evidence which has brought to my notice continued in the deposition of one Jharkhand, DT.13.01.2026, adduced by none else but the contesting defendant themselves. This witness is again a senior citizen, 70 years of age, belonging to the same village, Bandardona, where this disputed land situates. This witness in Para 6 has very clearly and categorically admitted that Shutar Mathur, Deva Mathur, Eni Mathur, Baju Mathur, Soma Mathur, Dukho Mathur, Lina Mathur and Libur Mathur, they are all cousin industry relations wise, and further admitted that there is no partition taking place among them till today. If the evidence of this witness is taken to be correct,
which indeed should be
correct, which indeed would be, I feel that the relationship of proportionality between Dukho and the other branches of the plaintiff and defendant is established alone on the basis of evidence. This witness is a senior citizen of the village, and I find no reason to disbelieve the statement of this witness on any account. It shall not be out of place to mention that the defendant 10 to 13 have also filed separate written statements, though which has been admitted, through which these have been admitted that
through which they have admitted that.
Through which, yes, it has been admitted that the Gloria Superior was proportional, and in Para 2 of the written statement, the genealogical table filed by the plaintiff has also been admitted to be correct in totality. Viewed thus, considering the pros and cons of the evidence on this issue and the invasive nature of denial of defendant and the positive and the cogent evidence registered and given by the plaintiff, I am of view that this important issue whether the Gloria Superior, the recorded tenant of Ada number 33 was a descendant of J.R. Mathur, decided affirmative, and it is held that he was a descendant of J.R. Mathur, and so this issue is decided in the present. Now, my lord, issue number 7.
Now let us analyze this. So far as this issue is concerned, there are primarily 5 reasons cited to decide this issue. One is that the defendant did not disclose in their evidence, and in their cross-examination also it was completely evasive as to who was the father of Bhikkhu. This is one reason.
But
The second reason which they have cited
Right.
is that the evidence of one
Lakhan.
person, namely Lakhan Mehta,
DW7.
DW7,
He
right?
had admitted with regard to genealogy.
Relationship.
Yes.
He has admitted, and he's an elderly person,
Yes.
right?
And apart from that, the 10 to 13,
Yes.
who
The
are
10 to
also
13,
the family, within the family.
they had
family
also
people,
admitted
They have
the-
also admitted with regard to this.
with regard to
These are the
this.
three main reasons
Right.
which have been recorded for giving such findings.
That's right. These are the primary reasons for giving such finding. Okay. Now, other would be issue number 7.
The trial court has also considered that the denial is not specific, rather it is an evasive denial.
That's
An
right.
evasive denial, as per the order 8, it is considered to be addiction.
That's right.
Now, Lord, you Lashmi may kindly see issue number 7. May I read?
Yes.
The issue, Your Lashmi, whether land
Now,
or other
these issues were also considered by the learned first appellate court.
Yes.
Okay. Issue wise, or the appellate court considered it in a different manner.
It has considered for the issues.
Issue wise, right? Same issues.
Same issues.
Okay. Now, since considering the nature of substantial question of law, we can see the finding with respect to issue number 8 by the learned first appellate to compare. And which reason, according to you, has not been met
Yes.
by the learned first appellate court?
But let's see, let me cover the less fast one. The issue number 7 of the trial court. Then I will come to it.
Yes.
Issue number 7, Your Lashmi, whether the land of the Khata number 23 of village Badar Bela is a proportionally property of the community condominium.
Yes, yes, I'm there.
In this context, I would say that it is a specific case of the community that the landed property of Khata number 23 of Badar Bela, though recorded separately in the name of Budia Sukhriya, but as a matter of fact, in the law both it is constituted a proportionally property. On the other hand, the contesting defendant B and C have categorically denied the same, having constituted a proportionally property, rather they have asserted that it was a separate property of Budia Sukhriya. At this juncture, I would like to mention that once it is held that the Budia Sukhriya was proportional and was common descendant of common ancestor, the strong presumption of jointness of property is held against this. Law is very clear on this point that the jointness of property is the rule in the proportionality of family, and the separate status is a matter of fact which requires a specific and cogently proved and established by the parties so pleading. So, with regard to landed property of Khata number 20, the strong presumption is raised in favor of plaintiff that the property was proportionally, and now the burden lies on the contesting defendant to prove that the property of Khata number 23 was the separate property of Budia Sukhriya. Even in the pleading, there is no averment to that effect as to how and in what manner this property was separately acquired and possessed by the Budia Sukhriya. Not only this, even during the entire evidence, I do not find any evidence given by the witness as to how the Budia Sukhriya came over the property as a separate owner, unconnected or proportionally property. The learned counsel for the defendant has drawn my attention towards certain exhibits through which they attempted to persuade to believe their contention that the recorded tenant of Khata number 23 Budia Sukhriya was not the proportional and the property was his own and separate. In this connection, exhibit B has been shown, which was Vibanam, issued by Mosman Chokri in favor of contesting defendant. Rupan. This deed date has been excluded in the year 1944. I do not find anything in it which can positively support the contention of the document. Similarly, my attention has been drawn towards the Exhibit C, cell deed excluded by Musman Somli in favor of three persons, Deva Sokaria, Beni Sokaria, and Mahu Sokaria, Nanu Sokaria, and also in favor of Chutar, who is the father of the plaintiff. This shell deed is quoted in the year 1944, and in the body of the shell deed it has been written that the vendor is selling the land of her own husband. This is the evidence which the defendant wants to use against the plaintiff to establish that the land of Pata number 33 was never a proprietary property. Because the father of the plaintiff, Chutar Mahu, through his registered deed purchased out of 33, and in the same deed it is stated that Musman Somli has sold out her husband's own land. It is submitted that now the plaintiff is bound by estoppel from denying the contents of the deed that the land of Pata number 33 was a proprietary property and not a sole property of Musman Somli, that is Julia Sokaria. On this point, when the counsel for the plaintiff submitted that the plaintiff had no knowledge about this document and further submitted that this document has not been produced by the plaintiff side, rather it was being produced by the contesting and has never acted upon this survey. And also in this context drawn my attention toward the evidence of one witness, that is plaintiff himself. And he in para 29 has specifically stated that he does not know as to whether Rudia Sokaria or his wife Somli has ever sold any land during the election. In this context, when this argument was being advanced was elected, then a counsel from the defendant produced another study on 24/4/2004, which has been marked as Exhibit C by 1 with objection of the plaintiff, and the plaintiff has seriously objected on the admissibility of this document and the juncture. And at the juncture when the argument was almost concluded, because it has given a surprise to this case, and this document was never adduced before this case. Before in this case, I have forced in submission of the learned counsel for the plaintiff, and this exhibit cannot be used against plaintiff because it has been put surprise to this case. I also feel proper to say that this kind of tendency of rendering document at the 11th hour of the trial court of suit be discouraged, and even if for sake of argument, the exhibit C and C by 1 is taken into consideration. It is simply speaks that plaintiff parent has read consumptions in Khata number 23, land of the mother villa with certain express requirements in theology in the body of the cell exhibit 6 that the land was sold was Wendy's husband. And then exhibit C by 1, the mother of the plaintiff, Mosmat Aguni, sold the same to other persons. Referring the acquisition through study, which is exhibit C, is alone in the evidence on the basis of which the defendant wants to put an estoppel against the plaintiff on denying the joint status of Khata number 33 using a small amendment to the body of the exhibit C. The estoppel is a principle based on equity, and it has to be weighed and judged in its real pursuit. A simple amendment in the body of the study of when the party may not access while disputing the same cannot alone operate as an estoppel, especially in a situation where there is no other evidence supporting the same, and rather, contrary to it, there is mighty presumption of law of jointness status over the property being the proportionally. Apart from the presumption of jointness of proportionally interest over the landed property of Khata number 33, I find the defendant 10 to 13 who have filed their separatism statement have admitted in para 3 of the written statement that the landed property of Khata number was a joint property, and after lapse of DT branch, the total property devolved upon the next elements of Kolia Sokolia, who then else was the bench of the plaintiffs and the defendants. It is true that one being compassionate can acquire the independent property, but the burden lies on him to establish that the property was separately acquired by giving potent and confined evidence. Otherwise, the entire property will be taken to be law of blankness, and the compassionate concept will form a part of compassionate. There is no evidence given by the defendant as to how and in what circumstances, by what means this land of Khata number 30 was purchased or acquired separately by Budia, Sokalia, the recorded tenant of Khata number 33, who has been found by this court to be compassionate with the other plaintiffs and defendants. In continuation of my finding on the point of jointness of property of Khata number 33, I would like to advert that the Khata land of Khata 22, which is the item number 2 of Schedule A property situated in the village no dispute from pleadings of the party and even during course of argument, the learned counsel or the respondent has submitted that this property be subject matter of the partition among the parties. On the reasons discussed above, I am of view that the landed property of Khata number 23 was denied and compulsory property of the party, and accordingly issue is decided in the court.
So the landed property of Khata number 33 was declared to be a joint family.
Joint family property.
What about the Schedule 2 property?
So schedule 2, there was no dispute. Accordingly,
There was no dispute.
they are also not disputed. Everybody has rights what they have shown. I was reading it, but it was not very visible, so I could not read it properly.
But they have, what is that? So
Item number
ultimately
2
the
of Schedule A property is situated in not in the Malad has made it, it's a 5 copy must be there. So I am reading page 19.
Page 19.
On the region discussed about, just उसके पहले वाला था.
हाँ ठीक है उसके पहले in continuation of my finding.
हाँ इसमें लिखा है ये कि I would like to advert that the land of Khata number 22, which is the item number 2 of Schedule A property situated in village, is not in dispute, but perhaps it is not in dispute. From the pleadings of the party, and even during course of argument, the learned counsel for the defendant has submitted that this property is subject matter or not the subject? Something else. Partition among the parties.
Means that they,
Not dispute what they are saying.
so
Actually,
not dispute means what? It was also to be partitioned.
yeah. So my submission would be if there was no dispute to that effect, and the parties can agree, there was no occasion for the learned appellate court to reverse the whole one.
There was no occasion for the learned court to reverse the finding with respect to
Schedule
item number 2.
Two also. Because they were also not disputing.
But there is no discussion of item number 2 in the entire judgment.
Because they were not disputing. They are
Not disputing means what?
Not disputing means admitting.
They did not dispute it in the written statement.
Yes. That what is the right? That is which is the
No, in the written statement they have stated about Schedule 2 property
Schedule
also.
1.
They have not whispered a word about the written statement. In the written statement with respect to Schedule 2 property, have they?
I have a copy of the
Look at the written statement.
I can show it from the text.
The contesting defendants were?
Contesting defendants is
3 and
3
6.
to 6. 3 and 6. It appears that there is no denial. But the kindly see the written statement. The only amendment is with regard to 33, Khata 33.
You read para 18 of the written statement of defend number 3 and 6.
The defendants have nothing to say against the treatment made in para 9 of the plate. Let me see what it
आगे पढ़िए
is. Never any partition is expected among the property.
But the plaintiff are called upon.
But the plaintiffs are called upon to involve lands of all other khatas, including land of khata number 11, in case partition of the defendants are also entitled to share of land. No specific denial.
No specific denial. So, with respect to Schedule 2, there was no reason to reverse the finding.
But the reason they have assigned separate kabjawari, etc.
With respect to
Item.
but the trial court is not discussing anything.
Because they have admitted it, there was
Yes.
no occasion for the decision, any decision or indication. When there is a denial, only then there can there is issue of our adjudication.
The para number 22 is also there. Para number 22 is also there.
It's a general.
No, para number 20, sorry, 20.
22.
20 of the written statement.
It is stated that the plant is not correct and denied that it is denied the land.
Okay, go. There is a denial. It's not that.
Denial with that they are what they are saying actually that Baudio Sakaryar had no relationship with so far as the 33 is concerned. 22 is. 22 is not the his name is not there. It is in the name of the 3 brothers. That is altogether a separate one. And the bone of contention is khata number 33.
What about the appellate court?
Yes. That is the reason why the trial court has recorded that.
But otherwise there is no discussion.
Otherwise, there are discussions also. The reason is because there is no specific denial. I would like to point out the operative portion. It is accordingly ordered. It is page 21. Lord, may kindly see page 21. It is accordingly ordered that the suit is decreed for partition in favor of the plaintiff to the extent of 1. In the landed property of Schedule A, which contains item number 1 and item number 2.
That's
Both fully described in Schedule. Now,
the appellate court.
may kindly see appellate.
can have a seat. Appellate court.
So far as the
Where is the point for determination?
base up to base 6, the cases of the parties have been discussed.
Yes.
My lord, may kindly see base 7.
Page 7. Okay, then the findings.
Yes, the same issues have been recorded.
Same issues.
No point of determination has contemplated with all of the
No, but the court can consider the same issues. Is
But
there any part?
The mandate of law, Your Lordship.
That's right. If the court says that each issue is important and they are considering each of the issue, then that will not vitiate the judgment.
Sufficient compliance, my lord may say.
Yes.
We can say that the sufficient compliance is there, but the law mandate, Your Lordship.
That's
that
right.
there should be a separate
No,
point of
that will not
determination,
be
so
shared.
that what judicial mind actually has been done.
Yes.
The Lordship may kindly see findings portion, para 15. Roman 4, Roman 5, Roman 6. Roman 4 is whether there is a unity of title or position. Roman 6, Roman 5, whether the land of Bodhya Sokaria in Khata number 33 is ancestral property. 6 is whether Somli was entitled to exclude duty. My lord, may kindly see, my lord, para 15. There is no dispute between the parties with regard to their ancestral land situated in Khata number 20. The reading line starts. In village Doniapur, both the parties admitted that they are in separate position of the same according to convenience and suitability, even during the last cadastral survey and settlement operations. The position of the ancestor of the parties and the dependents have been recorded separately over the land of Khata number 22 of village Doniapur. Despite that, it has been recorded. The main dispute surrounds the
The finding is there in para number 32.
I would like to show the para 24 first.
Yes, it is said.
What degree has been?
Para 32 also.
32, 34 also.
Yes, absolutely. Para 32.
30.
32.
On above discussions, I hold that there is already a previous partition between the ancestor of the party and defendants over Khata 32, and whereas the land of Khata 33 is not mentioned, none of the parties are intended.
So, with respect to Khata number 22, the court says that there was a previous pattern.
That what is defined.
Yes.
The mutual cultivation by consent has been taken to be a previous one.
That's right. Whatever it is, but this is the finding.
That what is defined.
And defendants have been recorded separately over the land of Khata number 22.
That is correct. 22.
They have also been, they were
Kabjawari
living
is
separately.
separate Kabjawari is there. But there are judgments to that effect that even recording of subject Kabjawari will not is not a conclusive proof for.
With respect to Khata number 22, practically there is no
There is
finding.
no.
There is no finding of the learned trial court.
And there is no dispute. I
No,
because there
with
is
respect to Khata number 22, there
But-
is certain finding of the learned appellate court.
but
Trial court has not recorded any finding with
trial
regard
court has not recorded it because there was no dispute as such. They have admitted this. When there is no dispute, not recorded. Admitted that you have nothing to say so far as the Khata number 3 is concerned. And even as per the Kabjawari also, one had dwelling title, I agree.
They are already in possession of 1/3.
Already in possession also, and
Separately
admitting
recorded
also,
also.
and admitting also. So that's why they did.
Was there any plea of previous petition?
No, there is as such no, I just read out my lord also.
Plain we have not read.
My lord,
The written statement we have not read. We have just perused the written statement of the contesting respondent. What about the other respondents? Was there any plea of previous partition? Is there any plea of previous partition? Like this? There is no plea of previous partition.
No, plea, no. There was a vague denial with respect to proportionality also, which has been taken not by the trial court, and not virtually as such no specific denial with respect to khata number 22 also. Our case was very specific that it is a proportionality property and we are all descendants of Juhal Mahto, Bolio Sokariyar, his father Biko was also one of the sons, and when everybody died, the property went to evidence. And we are entitled for 1/3 share in khata number 133 as well as khata number 20. My lord, may kindly see the plan. Para 2, your lordship may kindly see.
The plea of previous partition would have come in the written statement.
Written statement? How can I ask? No opinion for us. And he is also not saying so anything like that. Virtually, the bone of contention, it is khata number.
And there is no issue also about previous partition.
There is no issue also. There was the only issue about unity of title and possession.
Sorry?
Only issue is about khata number.
Unity of
So
title
the
and
point
possession.
is that if the khata number 33 was the only bone of contention, then why the partition in connection with khata number 22 has also been satisfied?
Yes.
Right? This is something that you need to answer. आप हैं बालेश्वर
Sanjay Kumar Pandey.
संजय
Baleshwar Yadav had given me file just due to my personal difficulty. I placed some accommodation. जिसमें केस में टाइम मैटर
नहीं, ऐसा नहीं हो सकता ना, आपने कोई एडजमेंट नोटिस भी नहीं दिया, ऐसा नहीं हो सकता। कल आपको सुन लेंगे, बस इतना ही बता।
जी, हाँ,
लेकिन आप समझ लीजिए,
हाँ, ठीक है।
खाता नंबर 22 में,
हाँ,
ठीक है, एडमिशन के बेसिस पर जो है डिक्री हुआ था ट्रायल कोर्ट में, खाता नंबर 22 का विशेष कोई डिस्कशन नहीं है। The appellate court is saying that there was a previous partition, right? And on the basis that separate kabja wadi is recorded, but there is no plea of previous partition. In absence of any pleading that there was a previous partition which was followed by a separate kabja wadi, there was no occasion for the learned first appellate court to come to a finding that there was a previous partition. Under the joint family, if the separate persons are holding property separately and by way of convenience, and even if it is in possession of one or the other person, the same does not mean that the property is not a joint family property. Family is joint, it is not in dispute. Previous partition का तो कहाँ से आया है ये आपको बताना है. From where do you get this previous partition, the first appellate court? Okay, with respect to खाता number 22. अब यहाँ is खाता number 33.
Para 15. Married.
Yes, para 15.
Para 15, I have already read it. I have already read out portion I have read out. Again, it is 15. Okay, para 15. I have there is a dispute. Main dispute surrounds the khata number 33 of Bandar. The matter. Plaintiffs claim that the recorded tenant of the said khata named Buria Subayar was the recorded tenant of said was a sister of natives and defendants, and the lands were also joint proportionally property to which the properties are entitled to equal share. Parties are entitled to equal share. The plaintiff have claimed that Buria Subayar, recorded tenant of khata number 33 of village Bandar is the son of Buria Subayar, whose father was Jihan Maman and sister of both parties. According to them, Buria Subayar was the eldest of the Jihan. On the other hand, defendant number 3 and 6 had claimed that recorded tenant Julia Sukaryar or his father Nico Sukaryar of village Vela were not from the family of Jalan Mahtu of village Donya. They had no concern with the said family and the Jalan Mahtu was not the common ancestor. Julia Sukaryar is recorded separately in the cadastral survey and the settlement of operation for the land of Khatana Bhattacharya village Vela and none of ancestor of relatives or dependents have been recorded in the state. In fact, after death of Julia Sukaryar, his wife Shukri was looked after by the Rupan Mahto and Beni Mahto, ancestor of dependent number 3 and 6, due to which the services rendered. Out of affection, Mosmat Somri executed a deed of gift in the favor of Rupan Mahto and Beni Mahto in 1944. He also sold land of Khata number 33 to the ancestor of plaintiff. Therefore, land of Khata number 33 of village Vela is not of joint family property of plaintiffs and dependents. It is not liable to litigation. This is also the dispute between the plaintiff and dependent with regard to death of. There is also dispute with regard to plaintiff with regard to death of Julia Sukaryar and his wife. So, according to plaintiff, Julia Sukaryar died in the year 1955 while his wife died in 1944. Dependent number 3 and 6 have claimed that Julia Sukaryar died earlier in the end of 1943 or in January 1944 when Mosmat Somri died in 1960. The counsel for the appellant have submitted that the evidence on the record will go to show that Julia Sukaryar and his wife were not the families of the plaintiffs and dependents and they were not residing in the same house along with the ancestor of the party. They were residing at a different village and the name of Julia Sukaryar is separately recorded for the land of Khata number 23 of village Bangladesh. PW1 Baru Mahto is the plaintiff of the case. He admitted in part 17 that he lives in village Dunya and he has never seen Nico Sukaryar nor his son Ilyas. He claimed that he had seen Mosmat Somri and he was aged about 20 to 22 years at the time of his death. Therefore, PW1 must have been born in 1936, which means that Somri died in the year 1958. There is a direct evidence given by plaintiff with regard to the year of death of Mosmat Somri. In para 21, PW1 has further stated that he died, but he did not know the Julia Sukaryar or Somri had sold land during their lifetime, although the father of PW1 is one of the purchasers from Mosmat Somri. PW1 further pleaded ignorance in para 22 about sale of land of Khata number 22 of the Dunya. As in the complaint, he has stated that about sale of the land by PW14. Although in para 15, PW1 has challenged the deed of gift issued by Mosmat Somri and sold them fabricated, but no relief has been sought to set aside the deed of gift. Moreover, his father is a party to the purchase of land from Mosmat Somri. PW2 Budhan Mahto in para 10 has stated that Rupan Mahto and Beni Mahto had bought the land by the deed of gift issued by Mosmat Somri in Khata number 20. This fact has been corroborated by the Rajulan in para 20 that his father Rupan Mahto had no share in the land by Somri. In para 7, he admitted that he had got no land or house in village Vela, although he claimed to have been Mosmat Somri at the age of 50 years. He was aged 80 years of the time of his death, which means that Mosmat Somri has seen by him in the year 1960. However, PW3 admitted in para 11 that Beni Mahto and Rupan Mahto used to reside near the house of the Mosmat Somri. This evidence goes to show that they were looking about after her and in view of the services rendered Mosmat Somri suited deed of gift. Further admitted in para 12 that he came to know from his father, the elderly people of village, that Julia Sukaryar was a son of their Mahto. This evidence is hearsay, since PW3 had not seen before Mahto or Julia Sukaryar. However, in para 13 he admitted that the ancestor of plaintiffs and dependents in the Bukhari Mahto, Ulas Mahto, Nanu Mahto had no share in the and Biko Mathur was not the family of the Bihar Mathur. PW4, Badri Prasad Mehta admitted in policy of the government that Biko Mathur and Beni Mathur had constructed their house at village Mandavela in which their sons resides. PW5, Rohan Mathur admitted that he had not seen either Bihar or Biko nor he had house or land at village Mandavela. However, he has stated in Para 8 that Chutar Mathur and Deva Mathur has told him that Biko was the son of the man. Tuleswar Mathur admitted in Para 6 that after death of Sundri, both parties jointly sold land of Khata number 23 with him, that he was stating that it was Sibarama, which is a said it disputed by family members of Nati with regard to the purchased land from those persons, which is not sound. Learned counsel for the respondent has vehemently argued that Exhibit C by 1, stated of the plaintiff, disputed in 1979, was not mentioned in the written material. And the document was filed at a very late stage, therefore it cannot be admissible. Learned counsel has also referred to the decisions referred to the quoted in AIR 1964 Patna, AIR 1974 Patna, AIR 1974 Odisha, AIR 64 Patna, AIR 67 Supreme Court in support of the sanction. It is well written principle of law that no evidence can be looked into without reading from the same. There is no dispute of certain position, but in this case contesting the comment are clearly stated in the interpretation that the plaintiff's ancestor Chutar Mathur along with other had purchased 2.60 acres from the Mosmat Sumri by the Exhibit 2. The state said it was acted upon by subsequent execution of sale by the plaintiffs by Siva. Therefore, it cannot be said that there is no pleading of the appropriate transactions made by Mosmat Sumri which was acted upon by the plaintiffs. PW8 and PW9 are the common witness have proved the rent receipts of plaintiffs. There is no rent receipt of any document of Khata number 30. On the other hand, PW1 Gender Mathur has corroborated his case and stated that the plaintiffs only claimed Biko Mathur was son of Dr. Mathur because Sokariya was son of India. Sokariya lived in village Mandavela and after his death, Mosmat Sumri after Rupan Mathur and Beni Mathur who had performed this art. Mosmat Sumri had located some land in Khata 23 in Beni Mathur and John Mathur. They came in cultivating position in the same Khata Mosmat Sumri 2.60 to other 3 branches of Beni Mathur. Thereafter, no land was left with Sundri after the gift. In 5 years later, when the purchasers sold the land means that plaintiffs are party to the said it, therefore plaintiffs do not claim protection of C by 1 in the late stage of the case, and they have been taken by surprise seeing their parties to the suit. It has been further stated that in Para 6, the Villain Mathur had no right over the lands of Khata number 33 and his sons required right title by purchase. In Para 8, it stated that because of Kariya, who was a resident of village Mandavela, Vihal Mathur was a resident of village Koloni, he states that in Para 11 he had performed Sraddh of Mosmat Sumri, and at that time he was aged about 15-16 years. The court below had given a finding in Para 10 of the Hindu judgment and stated in Para 11 that they had performed Sraddh for Dr. Mathur and Deva Mathur had sold 8 decimals of land in Khata 23 which means that the finding is mine. It has been submitted that the finding is against evidence on the part since no document of sale has been filed by the plaintiffs to corroborate the official. The land of Khata number 33 had already been sold by Sundri while remaining lands were listed by her to become Mathur in Delhi. Therefore, if any land of 33 was jointly sold by plaintiff and defendants at the time of Sraddh, documents would have been brought on record to corroborate this. Moreover, it is not the case of the plaintiff that they have sold any land at the time of Sraddh of Mosmat Sumri in absence of any pleading. So, type of offense without any documentary proof is not admissible. I find substance.
You see, there is threadbare discussion of the materials based on record. And the court has recorded that the plaintiffs themselves had purchased property from Somri,
Yes,
right?
yes.
Therefore, which reason of the learned trial court? The learned trial court has unnecessarily put the onus on the other side, right? That they did not say as to who was the father of Somri and who was the husband of Somri or who was the ancestor of Somri. Once you say that Somri was your family member, it was for you to prove the genealogy. It was not for them to prove the genealogy.
So far as Malad,
And the conduct of the parties have been fully taken into consideration. If she was your family member, what was the occasion to purchase the property from her?
there is no bar. You're asking kind of question.
No, but
Malad,
not now. The point is, just a moment. Now the point is, they will say that undivided share, and one of the sale deeds has not even been exhibited before the court. It was relied upon.
That has come from his evidence, the definite evidence. That I will show you that.
No, you have also purchased the property from Somri.
Not make idea.
But has the point is has these points which have been discussed by the learned trial court has been discussed by the learned trial court which has been
certain points have not been discussed. I'm coming.
so if certain points have never been discussed by the learned trial court, then certainly it will be discussed by the learned appellate court.
The trial court may consider the reasons or whatever independent.
What is the reason? What is the reason to hold the genealogy that she is not the relative of the plaintiffs? Just see the reason what the trial court has cited. That reason itself is perverse.
My lord, one by one. Our specific case was that my lord, the Biko was son of Jharkhand, and my lord, so far as the defendant is concerned, there was no specific denial. That is my first point.
No, that is not the case. They denied.
Denial, but
what specific denial? If I say that he is not the son, what further do I have to say? Do I have to also say that he is the son of such and such person?
Yes,
not
yes,
necessary.
You are supposed to say.
No, not necessary. I am not.
It is supposed
the
to
defendant is not supposed to give the actual genealogy of the person. The moment you say that he is son of such and he is my family member, the genealogy is required to be proved by you.
Not make earlier question. Lakhan Mahato, I had shown my lord the evidence which has been relied upon by my lord the trial court to my lord conclude that he is a family member. That is a very important material evidence.
The startling evidence.
Yes.
The startling witness.
That has not whether has been taken into consideration.
He was examined as
DW7.
DW7. Let us see the discussion of DW7.
Yes.
Yes, it is there at internal page 13. Internal page 13 of the appellate court statute.
Yes. DW7 stated in para 3 that Sobinar was not son of the Jharkhand and he was revealed about such at the time of that. This goes to show that in the year 1931, DW9, Garnath Mishra, only this much.
This goes to show that DW7 was born in the year 1931.
Further, he started discussion DW9.
Yes. So he was not the son.
Then he said.
He was not. The DW7 says that because Sokiar was not the son of Jharkhand.
Let us see this examination.
Yes, let us see. DW7 DW7. history has stated in paragraph 3, and paragraph 3 has been completely omitted by the Lalit Tribunal. Yes. इतना लोग कजन भाई हैं, इतना बोला है. So what? You've got this evidence. DW7 का evidence है आपके पास? Mr. Sharma, आप पढ़िए.
पारा 6 में बोला है।
पैरा 3 भी तो पढ़िए ना.
पारा 3 पढ़।
पैरा 3 पढ़िए.
जेहर महतो का नाम मैंने सुना। जेहर महतो का बेटा भिखारी महतो है। भिखारी महतो को मैंने नहीं देखा। जेहर महतो को 3 लड़का हुलास महतो जेहर महतो का लड़का या नहीं मैं नहीं बता। हुलास महतो को मैंने नहीं देखा। नानू महतो व जेहर महतो को मैंने नहीं देखा।
इनके हस्बैंड का क्या नाम है? वो लेडी के हस्बैंड का क्या नाम है? जिसका प्रॉपर्टी है उसका हस्बैंड का नाम क्या है?
जहर वाले कॉमन
सर मुसम्मद सुमरी के हस्बैंड का नाम है बिल्कुल सुन लिया।
दीको.
इसका 3 लड़का है।
तो ये तो बता रहा है इसका.
भिखारी महतो, उल्लास महतो और नानू महतो ये 3 लड़के इसके हैं। हम लोग भिखारी का नेटिव हम लोग भिखारी का हम लोग क्या नाम है और उसका एक दूसरा लड़का था उसका नाम था भीखो सोकरिया। उसका ग्रैंडसन है बौदियो सुकर।
ये भीखो सोकरिया ये
भिखारी महतो है।
DW7 जो है where is he saying that Bhiko Sokriya was the descendant of
that what I was वो तुम पढ़ रहे
ये आप पूरा एविडेंस पढ़िए. पन्ना का नहीं आप पूरा
6 नंबर पढ़े
आप पूरा पढ़िए.
चूटस महतो
आप पूरा एविडेंस पढ़िए.
आप पूरा पढ़
DW7
देवल महतो का भिखारी महतो नहीं
आप पूरा एविडेंस पढ़िए. DW हां पूरा
पढ़। दोनों पक्षों को मैं जानता हूं। बंदरबेला और दोनाई मौजा के जमीन का झगड़ा। बंदरबेला वाली जमीन खतियान में बौंदी के नाम से। बौंदी महतो को मैंने देखा था। बौंदी महतो भाई में अकेले थे। बौंदी महतो के पिता भी भाई में अकेले थे। बौंदी महतो का कोई बेटा नहीं था। बौंदी महतो के पत्नी का नाम सुमली है। बौंदी की मृत्यु हो गई। दोनों की मृत्यु हो गई। पहले बौंदी महतो की मृत्यु हुई। बौंदी महतो और सोमली महतो का रूपन उससे सहमति थी तो उसमें 6.5 एकड़ जमीन बंदरबेला में था। सोमली 3 एकड़ 90 डिसमिल जमीन महतो और बेनी महतो को दान पत्र में दे दी थी। शेष जो 8 डिसमिल जमीन सोमली ने देवा महतो, बिना महतो, चिटर महतो, नानो महतो बिक्री कर दी। खरीदार लोग अपने खरीदी जमीन पर है। दान पत्र वाली जमीन पर भी यहाँ लोग दखलदार हैं। वे लोग दखलदार हैं। सोमली का बंदरबेला मौजा में कोई दान नहीं। दोनाई वाले जमीन को सभी हिस्सेदार अपने अपने हिस्से आवाज करते हैं। पति परिचय
ये बौंदी महतो के पिता भी भाई में अकेले थे.
डिपेंडेंट का
बौंदी
विटनेस है।
महतो यस
डिपेंडेंट का विटनेस तो उनके प्रमाण में बनेगा।
हाँ बोला है.
हम पर्टिकुलर पढ़ना चाहते हैं
हाँ ठीक है पढ़िए.
तो उनके पास में नहीं बोलेगा तो उनका
That's
केस
right. हाँ.
मेरा विटनेस ही नहीं है उनका विटनेस। जेहर महतो का नाम मैंने सुना। ये एडमिट कर रहे हैं कहाँ जेहर पर सुने। जेहर महतो का बेटा भिखारी महतो अपने बारे में बोल रहे हैं कि हम लोग उनका लड़का नहीं। भिखारी महतो को मैंने नहीं देखा था। जेहर महतो का 3 लड़का हुलास महतो जेहर महतो का लड़का था या नहीं मैं नहीं बता सकता हूँ। खिलाफ पार्टी को भी बोल रहे हैं मालूम। हुलास महतो को मैंने नहीं देखा। नानू महतो व जेहर महतो को मैंने नहीं देखा। भीखा महतो को मैंने नहीं देखा। भीखा को भी नहीं देखा। भिखा महतो को भी नहीं देखा। भिखा महतो का नाम मैंने सुना। भिखा महतो जहल का महतो का भिखा महतो बेटा जहल महतो का ही नहीं। वादी महतो को देखने से मेरा उम्र 15 वर्ष था। उस समय वादी महतो की मृत्यु हो गई थी। लगिया सकरियान मृत्यु के समय उसकी पत्नी सोमनी जीवित थी। उसकी लड़की हन्नी के मृत्यु पिता की मृत्यु के 1.5 वर्ष के बाद हुआ था। हन्नी को मरने के करीब 10-11 साल के बाद उसकी सोमनी मृत्यु हुई थी। बोधी महतो एवं उनके मृत्यु के बाद बंदरवाली में रूपान महतो वगैरह रहने लगे। बोधे महतो एवं उसकी पत्नी के मृत्यु के बाद बंदर जिला एवं दोनाई खोज वाली जमीन को रूपान महतो वगैरह जोतने लगे। चूटर महतो, देवा महतो, रूपान महतो, बेनी महतो, बैजू महतो, भजू महतो, सुना महतो, भिखू महतो, दीना महतो एवं डिंगुल महतो सभी आपस में चचेरा तो कर दिया।
ये भीखू में तो कहीं बोलते हैं भीखू में तो कहीं बोलते हैं बोंदी में तो
भीखू है। भीखू उसका बाप है, बोंदी उसका लड़का है। जहर का लड़का।
लेडी का क्या नाम है?
सोमरी।
सोमरी।
सोमरी वाइफ है बोंदिया सोकरिया।
सोमरी वाइफ है
बोंदी सोकरिया। अब बोंदी सोकरिया का हम लोग के हिसाब से उसका पिताजी का नाम भीखू।
बोंदी बोधी
बोंदी सोकरिया।
इसके फादर का नाम क्या है? भीखू।
भीखू और उसके पिताजी का नाम जहर। नहीं क्लियर? हमारा यही
कैसे क्लियर? देखिए एक बात बताइए, ये PW7 has been heavily relied upon by the DW7, right? पहले तो ये बताइए कि बोधी की वाइफ है सोमी अनडिस्प्यूटेड है। ये तो दिस इज अनडिस्प्यूटेड, करेक्ट? Now, Bhikkhu is the son of Bodhi.
Jher.
Or Bhikkhu is son of Jher. This is also undisputed.
No, they are saying that he is an outsider to the family.
Who is outsider? Bhikkhu or Jher? Bhikkhu is outsider.
Bhikkhu, Bondiya, both.
Oh, Bhikkhu is outsider. Firstly, Bhikkhu is naturally Bhikkhu is son of Bodhi. Bodhi is son of Bhikkhu.
Son of.
Is it in dispute?
No, they are disputing it. Our case, this is what are our case.
They are disputing. There are two more relations which are to be seen.
Yes.
One is whether Bhikkhu is son of Jher. Disputed.
Yes.
Correct?
Yes.
Now, second relation is whether Bodhi is son of Bhikkhu. This is also disputed.
Perhaps they are not disputing.
Okay. This is what is disputed is whether Bhikkhu is son of Jher.
They are saying actually that what is our case is that Jher Mahato had actually 4 sons. Out of that, Bhikkhu Marat died deceased and survived by one son Bondi Sokaria. And this property was actually in the name of Bondi Sokaria. But all the Marat sons of the Jher and predeceased grandson also, they will have all the rights. That what is our. And when everybody died, then
you see, unless you are able to prove that Bhikkhu was son of Jher.
That what is
this statement I want to say. Where is Bhikkhu and where is Jher? In paragraph 6. In paragraph 6.
Yes.
Yes.
Where is Bhikkhu at?
Jher.
Here.
Yes.
Jher is the common ancestor. Your Lordship may kindly appreciate.
Okay.
Jher is the common ancestor. And Malad, he had Malad 3 sons. And Malad, one predeceased son, Malad, his name was Bhikkhu. And through whom Malad, there was a son that is Bondi Sokaria. And Bondi Sokaria wife is Somri. Malad, may kindly see para 6, he is saying Tutor Mato, Deva Mato, Rupan Mato, Beli Mato, Baju Mato. These are all plenty of different names.
Bhikari Mahto is who? He is different from Bhikkhu.
Bhikari Mato is my ancestor.
Bhikari Mahto and Bhikkhu are two different persons. He says that Bhikari Jher Mahto had 3 sons in his cross-examination. Right?
Bhikari Mahto ko bol raha hai ki hum
Jher Mahto had 3 sons. This is what he is saying in paragraph 3 of his cross-examination.
हाँ कल
तीन ही, चौथा बेटा का बात नहीं कर रहा है।
नहीं कर रहा, लेकिन चौथा बेटा का नाम तो ले रहा है। या छठा पैराग्राफ में देखा जाए, यही तो हमारा केस है। आखिर भीखू नाम तो कैसे करे, सब कह रहे हैं आपस में चचेरा भाई।
ये भीखू बोल रहा है, लेकिन हाउ डू यू नो दैट भीखू इज रेफरिंग टू दिस? बिकॉज भीखू इज, ऑन द वन हैंड ही सेज दैट ही हैड ओनली 3 sons. उन 3 बेटा में भीखू का नाम नहीं ले रहा है। You see, Bhikkhu is third generation. Bhikkhu is third generation and not the second generation.
No, Bhikkhu is the second.
Second. Therefore, Bhikkhu as per paragraph 6 is the third generation. Yes. You see, in paragraph number 3, he says that this Johar had only 3 sons.
Let us see the names of the plaintiffs.
ये देख लीजिए। जब ये बोलते हैं भीखू चचेरा भाई था, तो किसका चचेरा भाई था? हाँ।
प्लेट का जीनियोलॉजी
प्लेट का जीनियोलॉजी
प्लेट से ही
प्लेट में है। बताइए कहाँ पर है प्लेट की जीनियोलॉजी?
प्लेट 9
पेज 9। बताइए भीखू कहाँ पर है? कहाँ पर है?
पहला देखिए, यह बात हो गई, यह बात कौन?
ये 4 दिखा रहे हैं ना, ये 4 दिखा रहे हैं। You just see Bhikkhu Superior is the son of J.N. Mehta, first generation.
Son of J.N.
Mehta. So he is first generation. Right? So how will Bhikkhu Superior will become the cousin of all these persons?
I'm coming.
Yes.
Then your Lordship may kindly see Bhikhari Mata.
Bhikhari Mehta is there.
We are claiming through Bhikhari.
You are claiming through Bhikhari.
Next is Kulas.
Kulas.
Another is none.
Okay.
None. Now let us see who are the defendants and plaintiffs.
Yes. Who are the defendants as per the plaintiff?
Bhikhari Mato, Marat son is Johan Mato, and उसका आगे देखा जाएगा Tutor Mato. I got to see.
देखिए आप हमको इतना से बताइए इस जिनोलॉजी को खोलकर कि हाउ विल भिखारी यानी भीखू सोकियार will become the cousin of this भागिया सोनिया ये this Deva Mehto, Rupan Mehto, Beni Mehto. He is not his cousin. He is his uncle. The relationship is his uncle, not cousin. Cousin कैसे हो जाएगा? Uncle होगा. And this has to be read with para number 3, where he says that he had only 3 sons. There is no mention of the 4th son. चौथा बेटा का नाम नहीं है in his evidence, and he is your witness. He is their witness, okay, but you have cross-examined him, and this witness has been heavily relied upon by the learned trial court, right? चौथा भाई का नाम ही नहीं है इसमें. This is the clinching evidence. What else is required? क्या है मैटर्स? ये है ना कहानी.
यही कहीं पर भी नाम नहीं. तो चीट ऑफ पेपर में वो प्रोड्यूस किए हैं कि हाँ उनसे
और आपस में उन्हीं से खरीद भी जाए.
उनसे खरीद भी रहे हैं, सारा चीज उन्हीं से कर रहे हैं.
नहीं वो कोई बात नहीं, लेकिन पहले तो रिलेशनशिप जिनोलॉजी तो प्लेंटिफ को प्रूव करना है ना. If genealogy has not been proved, the matter ends.
भिक्कू का नाम तो ये है
भिक्कू का नाम, लेकिन भिक्कू इनका चचेरा भाई नहीं है, भिक्कू इनका चाचा है, चचेरा भाई नहीं है। यहाँ इतना कॉमन नाम होता है ना, भिक्कू हर जनरेशन में एक मिल जाएगा। You find भिक्कू in every generation, जैसे सोमरा और हर यहाँ पे कम्युनिटीज में हर जनरेशन में सोमरा, मंगरा, बुधवा आपको मिल जाएगा। एवरी जनरेशन हैज दिस नेम। जब तक बाप का नाम साथ में नहीं आता है, उसको आइडेंटिटी प्रूव नहीं हो सकता है किसी का।
पैराग्राफ 6 में लेकिन नाम
लेने से क्या होगा? चचेरा भाई बोलते
नहीं पैरा 9 में,
और पैरा 3 तो वो तो इग्नोर नहीं करेंगे ना, 3 भाई बोला है।
पैरा 3 में तो सिर्फ ये डर है कि हमको नहीं ना।
पैरा 3 में कह रहे हैं कि उनके 3 भाई थे, 3 बेटे थे, चौथा बेटा का नाम ही नहीं बोल रहे हैं। And he was born in 1931. He says that he had only
वो भी क्लियर नहीं
क्लियर है। जेहल महतो के 3 बेटे थे।
हम इसको
पढ़ी।
जेहल महतो का नाम मैंने सुना, कॉमन एंसेस्टर का नाम ही सुना है। जेहल महतो का बेटा भिखारी महतो का बात नहीं, हमारे बारे में आप कह दिए कि बेटा ही नहीं। भिखारी महतो को भी मैंने नहीं देखा, ये लिखा है जेहल महतो को 3 लड़का, उल्लास महतो जेहल महतो का लड़का था या नहीं मैं नहीं जानता। तो आपने खुद कंफ्यूज। और इसके बाद ये लिखे हैं कि उल्लास महतो को मैंने नहीं, नानू महतो को भी मैंने नहीं देखा, भिको महतो को पहले नहीं देखा, भिको को भी नहीं देखा, भिको महतो का नाम मैंने सुना हूँ, भिखा महतो का बेटा जहल महतो नहीं। इनका क्रॉस एग्जामिनेशन का इस पार्ट का कोई वैल्यू नहीं, क्योंकि कुछ भी एज पर दी डिफेंडेंट केस भी नहीं बोल रहे। डिफेंडेंट का केस है ये, तो सो फार एज मतलब जीनियोलॉजी विद रिस्पेक्ट टू
जीनियोलॉजी किसको प्रूव करना?
जीनियोलॉजी हमें प्रूव करना।
आपका कौन सा क्लिंचिंग एविडेंस है जिससे आपने ये प्रूव कर दिया है कि भिको सोकियार वाज द सन ऑफ जेहल?
तो हम दिखाते हैं। सबसे पहले तो एक तो इसमें 6 दिखाए हम भिको का,
उसका कोई रेलेवेंस नहीं है।
अच्छा, उसके बाद जब हमको स्पेसिफिकली पूछा कि भिको महतो का पिता नाम मैं नहीं जानता, भिको का पिता का भी नाम भी छुपा लिए
नहीं जानता।
नहीं जानता
भाई हर एक के पिताजी का नाम सबको पता होना जरूरी है।
सब चीज अगर आप जानते हैं और मुख्य चीज नहीं जानते
और डिपेंडेंट का एविडेंस मत बताइए, आप अपना एविडेंस बताइए।
अपना एविडेंस हम दिखा,
आपका कौन सा एविडेंस है टू प्रूव दैट?
अपना एविडेंस में T.13.01 करते हैं।
चलिए आपका कल सुनिए, आपको कल बहस करना है। और
इसमें एक चीज और हम कहना चाहते हैं, आप पार्टली जीनियोलॉजी आप रिलाई कर सकते हैं और पार्टली आप जीनियोलॉजी वेरीफाई कर सकते हैं, ऐसा नहीं। आप 22 के लिए आप सब कुछ आप मानते हैं, हमको आपको उसमें लड़का भी मान लिए, मेरा हकीकत भी मान लिए, वन थर्ड भी मान लिए, तो यहाँ मेरा सब कुछ। अब आप सिर्फ इस पर आप कह रहे हैं कि हम आपका
plot number, this khata number 22 was also recorded in the name of this Sonali.
नहीं जेहल महतो के वारिसान के नाम से।
जेहल महतो के वारिसान
में हम आते हैं,
आप आते हैं।
तो अभी आप उसके बाद इनका विटनेस अब हमको उनका वारिसाने मानने के लिए इनका कर दिया, ऐसा एविडेंस पर कैसे अपने कोर्ट रिलाई कर सकता है?
वो तो प्रॉपर्टी तो उनका है ही नहीं उस लेडी का।
नहीं आप प्रॉपर्टी हो चाहे।
देखिए जब आप टाइटल सूट फाइल के 2 प्रॉपर्टी फाइल किए, एक प्रॉपर्टी वो लेडी का है, ठीक है, या उसके हस्बैंड का है, दूसरा प्रॉपर्टी वो लेडी या उसके हस्बैंड के नाम से नहीं है।
नहीं वो एक इंटायरली डिफरेंट प्रॉपर्टी है, क्योंकि तीनों आदमी के नाम से है, जिसमें कुछ डिपेंडेंट्स भी है, कुछ हम भी है।
हाँ, तो अच्छा, उसके बारे में बोल दिया है।
उसके बारे में जैसे जब बात हो रही है जेहल का ही प्रॉपर्टी का ही, तो हम लोग इस पर सबका वारिसान मान कर रहे हैं। तो जब खाता नंबर वारिसान 22 पे हम जेहल का वारिसान है, तो हमको आप कैसे कह सकते हैं कि नहीं भिखारी महतो को हम जानते ही नहीं है, जेहल का होता ही नहीं, ऐसा एविडेंस अवेलेबल होगा वो आपका।
So according to you, in khata number 22, they will also be entitled to a share.
They are entitled. That what has been decreed.
What has been decreed by
It
the
has
Senate
been
trial?
provided trial for 1/3 इनको भी माना, मैं भी माना. तो जब एक
लेकिन अगर मान लीजिए कि वो genealogy proof नहीं होता.
नहीं genealogy.
Let us see अगर क्योंकि appellate court ने तो दोनों को डिग्री को set aside कर दिया.
नहीं डिग्री को एक तरफ से कहा है ना कि हम
दोनों प्रॉपर्टी का डिग्री को set aside किया.
डिग्री का set aside करने का कारण क्या है? डिग्री set aside करने का कारण है कि previous partition. ये नहीं कह रहे कि genealogy गलत है with respect to property. With respect to
वैसा तो pleading ही नहीं है.
वैसा pleading
उसका तो कोई मतलब ही
नहीं है. और 33 के बारे में इनका एक्चुअल में ये करना है कि 33 पर आपका हक इसलिए नहीं होता क्योंकि ये जहर का वारिसान का प्रॉपर्टी नहीं है. पहली बात. दूसरी बात कि इसमें आप परचेस किए हैं, एक बात ये कह रहे हैं. दूसरा ये एक गिफ्ट डेट दूसरे दिखा रहे हैं जिसमें हम गिफ्ट डेट पूरे हम को दिखाएंगे. सबका नाम सुकरियार लिखा हुआ. सुकरियार कैसे लिख दिए? नाम भी तो सुकरियार लिख रहे हैं. आप इस डॉक्यूमेंट पर रिलाई कर रहे हैं जिसके बुनियाद पर आप कह रहे हैं कि नहीं ये प्रॉपर्टी इसको कॉमन नहीं माना जा सकता. उसमें सुकरियार में डिफेंडेंट का नाम यादव होना चाहिए था, महतो होना चाहिए था. सुकरियार कैसे हो गया? ये सब चीज को रिलाई किया है तब ऐसा माना है कि हाँ ये प्रॉपर्टी.
ये ट्रायल कोर्ट का तो ये सब डिस्कशन ही नहीं
है. तो आपको दिखाया
तो ट्रायल कोर्ट का ये गिफ्ट डीड में सोकिया
लिखा पढ़े
कल सुनते हैं.
250
2:30
कल तो सेकंड हाफ.
कल छोड़ के दूसरी किसी और में कल तो 10:30 9:15 से कोर्ट होगा. परसों
कल 2:15 से ना वो ऑर्डर डॉक्यूमेंट मुझे 11 वाले हैं सब. The arguments of this case has commenced. The arguments have been made inconclusive. Post this case for further accuracy.
मेरा आर्गुमेंट कंक्लूडेड हो गया.
Concluded नहीं है, has commenced लिखे. ऐसे कैसे कंक्लूड कर देंगे? ऐसा थोड़ी हो सकता है. ऐसा नहीं. देखिए चीजें जिस तरह का सब्सटेंशियल क्वेश्चन ऑफ लॉ है ना पूरा ही सुनना पड़ेगा. कुछ तो उस तरह से नहीं है. अब ये खाली बोल देना कि उन्होंने डील नहीं किया ऐसा बोल के रिमाइंड करने का क्या पर्पस है बताइए? नहीं होगा ना वैसे.
ऐसे इंटरसी ट्रांजैक्शन इज अ स्ट्रांग प्रूफ.
Yes. Interstate transaction is a strong proof of jointness.
पार्टीशन का प्रूफ करेंगे जीनेलॉजी तो कम से कम पर आ जाएगा.
We'll see that.
टाइम नहीं होगा.
टाइम 10:30 कंटिन्यूटी में सुनेंगे. दूसरा केस सुनने में हमको दिक्कत हो जाएगा. अभी हम कंफ्यूज कर रहे थे फैक्ट्स. जब दो पार्टीशन सूट सुनना एट अ टाइम मुश्किल होता है. परसों सुबह 10:30 बजे पहला केस करेंगे. अमेरिकस का अपीयरेंस रिकॉर्ड करिए और रिस्पॉन्डेंट. अगर आप लोग को कुछ नोट बना पाए तो थोड़ा सा बना लेंगे तो इजी हो जाता है. ठीक है. आप तो सुन ही लिए सारा कुछ.
जी हाँ.
तो